All right, good morning, everyone. This is the state all-purpose calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and today is October the 12th, 2023. Today, we will address a variety of matters, including setting bonds, taking pleas, arraigning cases, and addressing other matters as necessary. We also have a probation revocation calendar, and I believe a DV reset calendar at 11 o'clock. All right. Are the public defenders currently at courtroom 2? Good morning, Mr. McLean. I see you.
Howard is here.
I'm sorry, you're muted. What were you saying?
Mr. Howard and I are here.
All right. Good morning, Mr. Howard. Good to see you.
You as well.
All right. What position are we beginning with?
There you go. Thank you.
We're going to start on the probation calendar. Good morning, Judge Williams. We're going to start with probation positions number 3 and 4.
Hold on 1 second. I said we had a probation. All right. Is probation on the line? Okay, I see Officer Allison. Good morning.
Good morning. Which ones you did not want to do?
Okay, he's position 3 and 4. This is Marcos Culberson.
Yes, it is, Judge.
All right, position 3 is just the probation violation itself. And Mr. Culberson, your underlying case is 20 CR 001103J. In this case, you were charged with battery, 2 counts of simple battery, family violence, and 1 count of cruelty to children in the third in January of 2020. All defendants, please pay attention. I'm going to tell you your rights so we don't have to keep reading them. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. This particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this particular proceeding. When I ask if you understand your rights, what I'm asking is if you understand those rights and how I'm conducting the hearings this morning. So do you understand your rights, Mr. Culberson?
Yes, ma'am.
All right, please raise your right hand. Officer Allison, please raise your right hand as well. Do you swear and affirm the testimony you give today of your knowledge and under the penalty of perjury?
Yes.
All right, sir, do you so swear? Do you swear, Mr. Culberson?
Yes, ma'am.
All right. What I'm going to do today is I'm going to listen to the recommendation from probation about how we're going to address your violation and see why they want to revoke you. And then I'll speak to your attorney to see what their recommendation is as well. Officer Allison, your recommendation?
The probation recommendation is to revoke. He was to complete a domestic violence intervention program, and he missed a revocational hearing of February 23rd. He only has 5 months and 16 days left on probation. He does not have enough time to complete that program.
Okay. Mr. McLean?
Your Honor, my understanding by reading the petition, first to get something out of the way, which perhaps from what I'm hearing is not the main concern. It says that he failed to pay $240 in fees and $54 in fees. And of course, that adds up to 6 months worth. And he says, well, that was waived while I was on DVIP or FVIP. And if we look at the paperwork, it'll show that the check mark was halfway between 2 things, and there was some confusion about that. I don't think fee paying is their main point, though. I think the main complaint of the probation department is that he did not complete the DVIP. Now,
Right.
he signed up, Your Honor, for a program through Defying the Odds. Defying the Odds was the name of what he signed up for. He completed a certain number of weekends. He describes to me that it was 4 hours every weekend that he completed. How many weekends of that did you complete? 5. So
that sounds like it's still not going to meet the requirements of the DV course, though, correct, Mr. McLean?
I described to him, I said, my understanding of DVIP, also known as FVIP, is that it's normally once a week, 24 weeks, which would constitute 5.5 months. I have been told that you can't shorten the course, and he wasn't trying to shorten the course. He was trying to do 4 hours every weekend, thinking he was doing that. Now, if defying the odds course meets the requirements of the DVIP/FVIP, that's great. But there may have been some misunderstanding on his part, Your Honor. It may be an honest mistake. He was signed up for an extensive course, and if it was not the right course, he substantially, I mean, if he put 20 hours into a course which was similar, I would ask the court to have mercy on him for that he was sincere, that he was trying. He
Do
did.
you have any information about the course now, Mr. McLean?
I do not. I just met him yesterday because we got an email saying that his private practice attorney, who had represented on this before, apparently had a scheduling conflict to another county and could not be here today. So we jumped in and I spoke with him yesterday, and we did talk at some length. And I also spoke with his mother for about 20 minutes this morning while I was dodging traffic on Ponce. I tell you what, he had.
Officer, 1 second. Officer Allison, are you willing to consider or review the course that defendant has taken to see if it might meet the requirements for what he was supposed to do for his probation?
If it's not a 6 months course, our agency doesn't accept it.
Won't accept it. Okay, so Ms.
Yeah.
McLean, it sounds like we're not gonna be able to work with the course that he in fact took, and it sounds like his probation will be revoked. I don't think that there's anything I can do. I understand he was attempting to, but he is required as a condition of the sentence to have taken that 6 months class.
Right. Now, sometimes there is an exception, Your Honor, and if we can switch over from the 24-week DVIP/FVIP to something like 12 anger managements, he certainly could continue on probation and get that done. He does work full-time, Your Honor, at a commercial bakery. They make literally the brand name Eggo things. They're located in North Clayton County, I believe. And they bake things and package them, and they are on the grocery shelves. So he's got a full-time job. He's got a child, and the mother of the child is in Virginia. So between his mother's schedule for surgery and the child's need to go back and forth to school, he's very much needed at work and at home, Your Honor.
If his sentence says, however, that he was supposed to take a 6-month class, I don't think the 12 months anger management is gonna cut it. I'd have to, go ahead. I'm sorry, Mr. McLean.
I'm sorry, Your Honor. Yes, but I have seen, for example, today, just by coincidence, yesterday, I was looking up where a 12-week, the FVIP course got substituted to a certain number of anger management classes in somebody else's case in a revocation hearing. And so I think it is possible to do that. And
He has 5 months left.
Yes,
yes,
it's 5 months, 5 months, 16 days.
and if you gave him 12 a.m. instead of the FVIP, he could get that done.
And he's already taken how many hours of this other class?
This other it's called Defying the Odds. He says he's taken 5 weekends, which would be 4 hours each weekend. He knocked out 20 hours of that.
Okay, I am gonna let him do the 12 weeks of anger management. However, I'm not gonna waive any fees. He's gonna have to pay the probation fees those entire time. And he needs to complete that 12-week anger management before the termination of his probation. All right, I'm allowed to continue. We're gonna report it as a violation. He's gonna complete the 12-week anger management course, and he's gonna pay all probation fees.
Thank you,
All right.
Your Honor. Yes, that will work.
Your Honor, could we do a report within 48 hours upon release, please?
Yes, yes, we can, Officer Allison. Thank you. You must report to probation within 48 hours of your release, sir. You understand that?
I believe you know where 132 Mitchell Street, 2nd floor is, do you not? All right, within 48 hours of being out of this jail, be there. 132 Mitchell.
And this is we giving you a second chance, okay?
Thank you, Your Honor.
All right. I believe this matter is now closed. Best of luck to you, sir.
This is still the probation calendar, positions 13 and 14, Scurlock.
Are you got?
Okay, Mr. Sherlock, the underlying charge here is a theft by shoplifting, 22 CR 0070665H, back from January of 2022. The other position is merely the violation itself. Do you understand your rights?
Yes, ma'am.
All right, Officer Allison, reminding you that you're still under oath. I am gonna swear in this defendant. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
Yes.
Yeah, all
Yes.
right, all right. All right, Officer Allison, your recommendation for the resolution of his violation.
He failed to pay probation fees in total of $120, victim crime funds in total $27, failed to report on April 20th, 2023, May 4th, 2023, June 30th of 2023, and July 28th of 2023. He did not complete shoplifting course.
Did he show up at all, Officer Allison?
I could look it up for you right now.
I'm just curious. I know you're saying he didn't come all those days and he didn't take the class, I'm assuming, and then he didn't pay. I wondered, did he show up at all is my question.
He did not.
Okay, your recommendation?
He has 6 months and 22 days left of probation. Probation is recommended for time served.
So Judge, obviously, you
Okay,
have to accept that recommendation.
all right, I didn't think you'd have a problem with that, Mr. Howard. All right, so essentially the time you served today, as a part of this charge, the Fulton County Jail will close out your case. If you don't have other holds at this time, you should be released from the Fulton County Jail.
Okay, thank you.
All right, best of luck to you. That concludes this case at this time.
Okay.
Positions 15 and 16, Mr. Walker, probation calendar.
All right. Good morning, Mr. Walker. Your case is, let's see, 22 CR 0028883D, in which you were charged with criminal trespass, family violence, as well as simple battery family violence. The other charge is merely the violation itself. Do you understand your rights?
Yes, ma'am.
All right. I'm going to place you under oath. Officer Allison, you don't have to respond. You're already under oath this time. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Officer Allison, your recommendation?
Mr. Walker did not enroll in Grady Intensive Care Unit. He failed to appear for a revocational hearing on June 13th, 2023. He has 72 days left remaining. Probation is recommended for time served.
And I'm assuming no objection to that, Mr. Howard.
No objection to that.
All right, same announcement. Essentially, the time you've served as part of this charge will close out this case. All right, if you don't have other holds, you should be released.
Thank
Thank
you, Judge.
All right, anything further?
Nothing further, Judge.
All right, best of luck to you, sir.
Positions 5 and 6, Mr. Frederick, this is still the probation calendar.
Okay. All right, good morning, Mr. Frederick. Your underlying case is 22 CR 00689 In that case, you're charged with battery from October of 2022. The other charge, again, is just the violation itself. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Officer Allison, reminding you, you're still under oath. Please give me your recommendation.
The defendant failed to pay probation fees in total of $160, victim crime funds in total of $36, failed to report on June 8th, 2023, July 10th, 2023, and July 28th of 2023. Did not complete 12 weeks of anger management. He has 24 days left remaining. Probation is recommended for time served.
As you follow that recommendation, Judge.
Okay. All right, sir. Essentially, the time you served in Fulton County Jail will close out your case. Okay, if you don't have other holds, you should be released.
All right, thank you, y'all.
All right, best of luck to you.
Positions 7 and 8, Kumar, probation calendar.
All right, Good morning. Your case is 22 CR 007877Y. In this case, you're charged with simple battery, simple assault. Underlying case date was November of 2022. Again, the other position is just the violation itself. Do you understand your rights first?
Yes, ma'am.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Officer Allison, you're still under oath. Please give me your recommendation.
He failed to pay probation fees in total of $40, victim crime funds in total of $9, did not complete 2 weeks of anger management, failed to appear for a revocational hearing on June 20th, 2023. He has 4 months and 22 days left remaining. Probation is recommended to continue on probation and to enroll in classes within 14 days and report to probation within 48 hours upon release.
And how long is the class he's supposed to take? I'm sorry, was 12 weeks?
2 weeks.
2 weeks, okay.
Yes.
All right, I'm inclined to follow that recommendation, Mr. Howard. Any response?
Yes, Judge. Actually, and I didn't have an opportunity to try out with Officer Allison, but given my conversation with Mr. Kumar, given his housing instability and some image concerns that we've talked about, I just don't believe it's practical that he will be able to complete the requirements that probation is asking for. So rather than setting him up for that circumstance, I'd ask the court to close this out. We understand it'll be considered a probation violation, but at this point, he's just trying to figure out how to live day to day, and I just don't believe he can get the class done.
How long has he been in Fulton County Jail on this charge?
I think he's been, Judge, I'm showing 10 days.
Yes, I think he went in on the 3rd.
On the 3rd of this month.
Yes, October 3rd.
Is there an option for a one-day class? I'm not as familiar with the courses that are out there. I know people don't like to split that baby, but I would like him to do something, Mr. Howard. You don't believe that he could complete a one-day course if I waive the probation fees?
The one day course I'm aware of is the one that pretrial does for free, but obviously it's not a pretrial situation.
Right, it's not a pretrial class.
But outside of that, I think he would have to pay to do it somewhere, Judge, and I don't know places that would do just one day. And just given, like I said, given his financial state and his everything I've talked with him about, I just don't know that he will be able to get it done. Not for lack of desire or unwillingness, but I mean, he literally is at the Presbyterian Church every day, just trying to, get food and just trying to, make basic necessities.
My question is he being released to any type of services, Mr. Howard, or he's just going back to the church?
Well, we're going to provide him with more options, but at this point, that's, if he gets out, he's going to be looking at some type of a, that scenario is what he's been doing up until now, up until he got arrested at the Presbyterian Church. He's been going there every day, which is they provide food. They don't provide housing, but they feed the homeless every day. So we certainly can connect him with additional options for housing. But that's it's just the monetary aspect of getting class done and getting there to do it wherever it may be. I just don't know if it's
And
real.
he's not likely to be eligible for PAD?
And as a PAD is at this point, Judge, I don't know. His case is closed, so that we can certainly connect him with PAD as well, because they since his case is actually closed out, they might be willing to work with him. So we can certainly point him in that direction in addition to the other resources. Since Ms. Patterson's probably here today, I can certainly let her talk with him and see if he would be able to go to PAD.
Okay, I will report this as a probation violation. The 10 days he served in the Fulton County Jail will close out his case. I don't believe there's anything additional. I'll allow probation to put their objection onto the record if you wish.
No objection, Your Honor.
All right. Best of luck to you, Mr. Kumar. This closes your case at this time.
Thank you, Judge.
Thank you, Judge.
Next, Judge, is going to be on the add-on calendar, position number 4, Mr. Nixon.
Judge, if I could ask, Officer Allison, if she could call me in the courtroom, I have one other case I need to speak with her about.
Okay, Officer Allison, do you mind giving Mr. Howard a call, please?
Hey,
If he could put the number in the chat for me, I can, yes.
Can someone put it in for, I'm not at my, I'm not on the Zoom currently.
What is the number? Can we know the number? What's the extension?
44612-2392.
All right, if somebody would please chat that to to Miss Allison, I would appreciate it. All right, this is not your case, is it, Mr. Howard? Chastis Nixon, before you walk off?
Pro se.
Okay.
Adamant.
Tell the judge. So she didn't know that. No, come on.
Who represent, oh, Mr. McLean, you do?
Your Honor, Mr. Nixon is pro se. He had a discussion with the court a couple of days ago. He sounded fairly adamant about being pro se. We could inquire today if he has changed his mind about that.
Let's do so. Mr. Nixon, you wish to represent yourself today, despite the seriousness of the charges you might be facing?
Yes, ma'am, Your Honor.
All right, even though Mr. McLean is there with you and highly qualified and willing to assist you, do you feel that you understand the laws of the state of Georgia sufficiently to represent yourself?
Yes, ma'am.
All right. Do you understand your rights today?
Yes, ma'am.
Okay, let me read you your case. Your case is 23 CR 005666. I'm sorry, there's too many sixes. 5666D. This case, you're charged with simple battery, simple assault, and criminal trespass, all with the offense date of August the 16th. And you've already told me you understand your rights. The announcement, I guess, is that you're pro se. So let me hear from the state. Whose case is this for the state?
Kalisha Body for the state.
All right, please proceed with your recommendation. Is there a plea offer?
Yes, Your Honor. We have a recommendation that we stated. We gave him last hearing as well. But again, it would be count 1, 12 months probation to serve 120 days, credit for time served 53 days, no further contact with Andrew and Emily Gianotto, and to stay away from the 1000th block of Euclid Avenue, as well as an ADET. As for count 2, the recommendation is 120 days, credit for time served 53 days. And for count 3, looking at 12 months probation consecutive with the count 1.
And he served that amount of time on each of those charges? Has
That
he
is
actually served the 55 days on each charge? Or would he have additional time to serve at the Fulton County Jail?
I believe he will have additional time to serve at Fulton County.
How much additional time will he have to serve?
We're looking at.
Because, and I have that he served 55. I know you said 53, but can we confirm?
Oh, yes, it would be 55. I apologize. That was from the last hearing. So we're looking at 2 days.
He would have 2 additional days to serve. Okay, sir, Mr. Nixon, if you were to take a plea offer today from the state, you would have to serve additional time at the Fulton County Jail, and there would be other requirements that the court really can't explain to you when you got out of the jail. Do you wish to take a plea offer?
Are you saying that they would give me the 2 more days if I take this plea and the probation, that would add up to it after they?
I can't fully explain the whole thing to you because I cannot give you any legal advice, but essentially what will happen if you take the state's offer today, you're going to have 2 more days to serve, and there's going to be other things you have to do when you get out, including some evaluations and staying away from locations. I really suggest that you let Mr. McLean assist you with this.
No, I'll plead guilty.
Your Honor, if I may, pardon my jumping in.
I studied law, so I really do not want assistance from the attorney.
I understand you don't, but sometimes we don't quite know what we need. Okay, all right.
Mind to plead guilty, please.
I understand that. Before we do that, Ms. Body, go ahead.
I'm not taking, we'll go to trial.
Okay, please hold on, Mr. Nixon. Just stop. Let me hear from Ms. Body. Ms. Body.
We're looking at 5 days extra. I apologize. I said 2.
So it will be 5 more days, and I'm bad at math, so I'm completely relying on you to tell me how many days he has.
Yes, Your Honor, it's 5.
Mr. Nixon, that would be an additional 5 days. There's other things that would be part of this. And you want to plead guilty? I have to ask you some questions if that's what you want to do.
Yes, ma'am.
All right. Is anyone at the jail going to be able to assist him with signing that plea paperwork if he takes the plea?
I would take it.
Your Honor, I can prepare the plea paperwork and
Right.
send it over. Is who is in the courtroom that I can email it to? Is Sergeant Norris there?
Your Honor, we do have blank plea and.
Oh, okay.
So I'll cross my name.
You're willing to assist him, Mr. McLean?
Right. I'll explain to him where the signatures go and where the dates go and what the questions are. And I'll find that recommendation and fill that in there if he doesn't remember what it was.
All right.
This
We're
is-
going to ask some questions to make sure it's a voluntary plea because we may not get to that part anyway. All right, Mr. Nixon, please raise your right hand. Do you swear and affirm the testimony you get? Oh, there is your hand up. Wait, please raise your hand for me. Thank you. That's your left hand. Please raise your right.
All right.
Thank you. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Ms. Body, because he is pro se, I'm going to ask for a little bit more to be added to the record. If you would please give me defendant's history as well as a very brief factual basis supporting this, and then I also will sound for the the alleged victims as I do see them on the screen.
Yes, Your Honor. In terms of his criminal history, he is a multi-state offender out of South Carolina, Tennessee, North Carolina, Florida, and Colorado. The defendant has been convicted of a host of crimes in each of these states. The record is deeply concentrated with multiple counts of felony and misdemeanor larceny, breaking and entering, assault by strangulation, assault against a female, disorderly conduct, shoplifting, possession, and resisting arrest. And these are all convictions in all 6 of those states. Additionally, as it relates to Georgia, the defendant had a theft by shoplifting arrest in 2018, a battery arrest as well, disorderly conduct, willful obstruction, and criminal trespass. Let's see. As to this specific incident, it was alleged on August 16th, 2023. The officer was dispatched to a fight call at the location. Upon arrival, he spoke with Mr. Andrew and Mrs. Emily Giannato, who stated that they were assaulted by an unknown male. Mrs. Giannato was driving eastbound when the defendant just came up to their car and started to punch and kick their vehicle. Mr. Giannato stated that he got out of the vehicle and told the defendant that he was going to call the police. And the defendant responded that he is the police, MF. The defendant picked up a rock at that point that looked like a boulder and acted like he was going to hit them with it. The victims were obviously concerned and scared for their safety. And they said it seemed like he was out of his mind and had no type of look in his eyes. He was just very out of it. And so that's what happened on that incident. And we would like to sound for the victims who he stated were on the call.
Okay. I see Emily Giannato. If you'd like to make a statement, I need you to turn on your camera and raise your right hand, please. You're not required to, however. Or Mr. Andrew Giannato. All right.
Yes, Your Honor, I'm here.
All right. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right. What would you like to tell me today?
That was pretty accurate. The one thing that was missing was that the defendant also punched me in the head as I got out of the vehicle and told him that we were going to call the police.
Okay. Anything else you'd like to tell me? All right. I appreciate you coming to court, making a statement. I know Miss Giannato said that she could not turn on her camera. We have to be able to see you. Oh, no, we can't read a statement in the chat. I apologize. That's not going to work. We have to be able to see you. You have to be able to raise your right hand and put it onto the record for identification purposes. Is Miss Giannato with you, Mr. Giannato?
No, she's not. I believe she's home or driving, not able to hop on.
Okay, well, we cannot read a chat. I apologize. You're gonna have to try to figure this out, Miss Giannato. I'll give you a few moments.
Your Honor, I will just say on behalf of the state, Ms. Giannato did communicate with us that the statement does represent, the statements that were made do represent what occurred on that date.
I'm trying to give her opportunity to take part of this proceeding, though.
Absolutely agree.
Let's give her a few. Okay. All right. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. What would you like to tell me?
The red statement expresses my opinion. However, the only other note I would make is that the incident was caught on camera. And so the responding officers were able to pull that from the traffic footage at the intersection.
All right.
I don't know this individual at all. Do anything to provoke this individual. The only other part missing was that he also threatened me, not just my husband. He said he would effing kill me and effing gut me. I cannot state again how much I have never seen this individual before. I've never encountered him. I believe that he is dangerous.
Okay. All right. I appreciate you coming to court and making that statement. All right. Mr. Nixon, do you still wish to proceed with taking a plea today, or do you wish to again speak with Mr. McLean to see if there might be other options for you? If you take this plea today, and of course I would have to ask you some more questions, you'd have an additional 5 days to serve in the Fulton County Jail. You'd have to have no contact whatsoever with either of these victims in this case. Stay away from the entire block of Euclid Avenue and undergo an alcohol evaluation and some treatment. So yeah, those are the requirements. Do you understand those? Or do you want to talk to Mr. McLean more? Because I cannot really explain them to you any further.
I'm ready to sign the plea and get this behind. Yes, I would like to sign this plea.
That is
All right.
He has not signed anything, Your Honor.
Okay.
This
All
is
right.
a filled out plea sheet. It has the case number in your name and the charges and the date. There's a space for you to sign.
I still have to ask him some questions before he starts signing. So
All right.
you do understand those requirements, Mr. Nixon? I have to see you. Please sit down. All right, thank you. You can sit. I just need you to sit forward so I can actually see your face. All right. All right. Now you understand the requirements of that sentence as we just discussed, all the things you would have to do.
I'll expect this. Yes, sir.
And you, did anyone force you to take a plea today?
No, they have not forced me to take a plea.
And you fully understand that you have a right to an attorney, but you're declining those services and wishing to move forward and represent yourself.
Yes, ma'am.
And you fully understand that by accepting a guilty plea today, you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you fully understand that there may be other consequences as a result of taking a guilty plea. It could affect other aspects of your life, such as employment, housing, immigration, anything of that nature that we might not be able to anticipate today.
Yes, ma'am.
And you're giving up your right to trial by judge or jury or to present any defenses you may have had.
Yes, ma'am.
And you fully understand that you can't have any other contact with either of the victims, either by accident or on purpose. You understand that?
Yes, ma'am.
And you understand you can't go back to the entire block of Euclid Avenue. You have to stay 1,000 yards away. You understand that?
Yes, ma'am.
And you also understand that there's going to be some alcohol evaluation and treatment as part of your reporting to probation. And you also understand you have to go to probation for 12 months?
Yes, ma'am.
Okay. As to the charges I listed earlier, Mr. Nixon, how do you plead?
I plead guilty.
I accept your guilty plea at this time. Mr. McLean is going to be gracious enough to help you fill out that paperwork. If you don't have, you still are going to have time to serve in the Fulton County Jail as it pertains to this case, okay? All right, I believe that concludes your case. Best of luck to you, Mr. Nixon.
Thank you.
Have a good day.
Probation 17 and 18, Mr. Whitfield.
I'm sorry, say that again?
Probation, position number 17 and 18, Whitfield.
Okay, Mr. Whitfield, you did not hear your rights. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. Do you understand your rights? Is that a yes?
Yes, ma'am.
All right. The underlying case we're here for is 19 CR 002850Y. In that case, you're charged with simple battery and battery. The underlying charge, the other charge is just the violation itself. Please raise your right hand. The Officer Allison, you don't have to, you're still under oath. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, Mr. Howard or Mr. McLean, do you represent Mr. Whitfield?
Your Honor, yes, I spoke to Mr. Whitfield yesterday,
Okay,
and I believe I saw a note that the warrant was withdrawn. Is that correct?
well, let's hear Officer Allison's recommendation. Officer Allison, your recommendation as to the resolution of this case?
Your Honor, it was a warrant dismissal that was signed and issued on July 5th. This case was closed back in July.
Okay. So this case should not be holding him in at this time, correct?
No, it should not.
Okay, so that this case is closed, Mr. Whitfield. I'm not quite sure why it showed up on today's calendar, but this case itself is not holding you in. Okay?
We'll check, Your Honor, if there's an order necessary from the court to take care of it, then.
Okay, maybe that's what happened. Maybe there needs to be an order.
And Judge, I don't know if we're strong, if she can check with Ms. Jordan to see if, you know, before we get too far along, if we need to do another order, because it's clearly holding him at this point, so it's a problem somewhere.
Okay, Ms. Strong, if you would take a look and see what might have happened as to why this case is still open or why it reached, why it appeared. Ms. Tyson, do you have some insight?
He has a felony case that's holding him in right now.
But not this case. We want to know why this case keeps popping up, I guess.
Yeah, it says the probation violation was dismissed and it says the probation violation is dismissed. He has a bond on a battery family violence, but he's on no bond on the other charges.
Okay, so this case is showing as dismissed.
It is.
All right. Thank you, Ms. Tyson. I appreciate that. Best of luck to you, Mr. Whitfield. This case is no longer an issue for you. Okay. All right. Who do we have next?
It's going to be on the regular calendar, position number 2, Mr. Bell.
Okay.
Royce
Mr. Bell, your case is 20 CR 001014C. You're charged with failure to maintain lane, driving without a license, driving under the influence, failure to maintain insurance, open container, and hit and run, all back in March of 2018. Do you understand your rights?
Your Honor, and I hate to interject, but Your Honor, he was outsourced to Cobb, so he was not available for interview yesterday.
You need to speak to him?
I need to speak to him if we go.
Okay, let me just, do you understand your rights though, so we don't have to go back to that?
Yes, ma'am.
Okay, so with that, we'll let you speak to Mr. McLean and we'll take another position.
Okay.
This is going to be on the probation calendar, positions 9 and 10, Mr. Michael.
All right, Mr. Michael, your case is 22 CR 004350C. You're charged with 2 counts of disorderly conduct with the offense date of July the 6th of 2022. The other, of course, is just the violation itself. You understand your rights?
Yes, ma'am.
All right. Officer Allison, reminding you you're under oath, no need to raise your hand. Mr. Michael, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Officer Allison, please proceed.
Mr. Michael failed to pay probation supervision fees in total of $160, victim crime funds in total of $30, failed to report on July 3rd, 2023, July 27th, 2023, and August 17th of 2023, did not complete a drug and alcohol evaluation, did not attend AA meetings, and failed to complete 40 hours of community service. Probation is recommended for time served.
All right, Mr. Howard, I'm assuming no objection to that.
No objection.
All right, essentially, Mr. Michael, the time you served in the Fulton County Jail will close this case. All right?
Yes, ma'am.
All right, if you don't have other holds, you should be released. Best of luck to you.
Thank you.
Positions 11 and 12, Mr. Overton, this is the probation calendar.
All right, good morning, Mr. Overton. Your case is 23 CR 00504C. In this case, you're charged with battery, obstruction, and 2 counts of obstruction with the offense date of January the 24th of 2023. You understand your rights?
Yes, ma'am.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. All right, Officer Allison, reminding you, you're under oath. Your recommendation?
He failed to report on June 1st, 2023, June 15th, 2023, and July 7th, 2023. Did not complete 8 weeks of anger management. He has 4 months and 16 days remaining. Probation is recommended for time served.
Okay, and I'm assuming there's no objection, Mr. Howard? All right, essentially I'm gonna accept probation's recommendation. The time you served in the Fulton County Jail will close out your case. All right?
All right, thank you.
All right, best of luck to you.
This is going to be on the add-on calendar, positions 1 through 3, Mr. Butts.
All right, good morning, Mr. Butts. Your case is 23. You have 3 cases. The first case, 23 CR 005901C. The second case, 23 CR 005902C. And 23 CR 005903C. In each of these cases, you are charged with criminal trespass. Do you understand your rights?
Yeah.
All right, and what is the announcement?
Your Honor, this is a negotiated plea in all 3 cases. Each offer is fairly simple. Each fact pattern is fairly simple and straightforward. We've discussed this extensively, and he asked the court to accept his negotiated plea of guilty in each of the 3. He will stay away from the Chevron on Buffington, and which is 2 of the cases, and he will stay away from the Dollar General on South Royal Parkway. He understands that very well. The state's recommending non-reporting probation, so this shouldn't be a problem in terms of performance.
All right, Ms. Nemini, will you put the offer? I know we have the stay away locations already for Mr. McLean, but the offer itself, will you put onto the record?
Yes, Your Honor. Give me 1 second. Okay. For
For the first one, for the criminal trespass, the state is asking for 12 months probation, serve 22 days, credit for time served 14 days, balance probated non-reporting, and to stay away from Chevron Food Mart at 5851 Buffington Road in Union City. For the second one, the same, the Chevron gas station at the 5851 Buffington Road, Union City. And then for the last count, the last charge, the stay away from the Dollar General at 3300 Royal South Parkway, South Fulton, Your Honor.
All right, and Mr. McLean, so that was his understanding. Do you stipulate to the 3 elements, Mr. McLean?
We do, Your Honor.
All right, Mr. Butts, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury? Do you
Yes or no?
promise to tell the truth today?
Yeah.
All right, I'm gonna ask you some questions to make sure you're voluntarily taking a plea and that no one's forcing you to do anything, okay? All right, Mr. Butts, I need you to answer me.
Is that okay with you? Yeah.
We can't take a plea if you don't understand what I'm saying, okay?
Yeah.
All right, are you under the influence of any drugs or alcohol at this time?
No.
Do you fully understand this proceeding and what's happening today?
Yeah.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking a plea? I'm sorry, what was that?
Let's speak up.
Did anyone promise you anything?
Uh-uh.
Okay, I need you to say yes or no because does sound like and I want to make sure that we fully understand what you're saying, okay? So we're gonna ask that again. Did anyone promise you anything for taking the plea?
Say-
Okay, I need you to say yes or no.
No.
Very good.
All right. And you understand that by taking the plea today, you're giving up your right to trial by judge or jury,
Yeah.
and you're giving up a right to have the state prove these charges against you beyond a reasonable doubt.
Yeah.
You gotta speak up now.
And you understand that you can't go back to that Chevron on Buffington Road, and you can't go back to the Dollar General on South Fulton. You understand that?
Yeah.
All right. As to the charges listed in each of the aforementioned cases, Mr. Butts, how do you plead?
Guilty.
All right. I accept your guilty plea at this time. Is there anything additional, Mr. McLean or Ms. Nimini?
Nothing at all, Your Honor. Thank you.
Nothing from the state, Your Honor.
All right. Best of luck to you, Mr. Butts. Don't go back to those locations. They do not want you there. All right.
Thank you, Your Honor.
All right.
Position 1, Mr. Banks. This is the regular calendar.
Yes. Frank Banks. I believe this is a negotiated plea, correct?
All right.
That's
Thank
correct.
you.
Thank you.
Hold on one
Very
second.
good.
My calendar is,
Number 1,
I see it, but I have something else. Something else is odd. Okay. I guess this is an additional add-on. I guess I'll figure that out later. Is there a Mason Reynolds on a calendar too? This also says position 1?
Your Honor, that's at 11 o'clock DVBW, domestic violence bench warrant.
No, that's a different calendar I have too. This one says, we'll figure that out later. That's not important. Let's keep going. All right. But yes, you're right. That is also on that calendar as well, Mr. McLean, but there's a different calendar that just popped up too. You're correct. All right, Mr. Banks, your case is 18 CR 0010455G. In that case, you're charged with loitering and prowling. With the offense date of November the 23rd of 2018. Do you understand your rights?
Speak up louder, please. Can you hear him, Your Honor?
I cannot. Do you understand your rights today, Mr. Banks? I still can't hear Mr. Banks.
A little more volume. I heard what he said because I'm sitting right next to him. but a
Just
little
say it,
more volume.
lean in and just, or nod your head. I'll take that today. I really will. Do you understand your rights? We're gonna assume that he does, but this might be difficult to take a plea if we can't hear. I have to be able to hear him to take a plea. Ms. Lemony, will you please put the offer into the record?
Your Honor, I can verify. He said, yes, ma'am, but he's just, he doesn't have a lot of volume to speak.
Okay, maybe we can move him slightly closer in time to take the plea.
Can you-
Miss Lemony, please put the offer into the record.
Yes, Your Honor. The state is asking for time served from the 11/28/2018 to 12/1/2018, and then 9/30 to 2023, which equals a total of 36 days.
Okay. And was that your understanding, Mr. McLean? And do you stipulate to factual basis, ID, and venue?
It is our understanding. We do so stipulate.
All right. Mr. Banks, I'm going to place you under oath, and I do need you to speak as loud as you can. Please raise your right hand. Do you swear and affirm the testimony you give today for the very limited purposes of taking a plea will be the truth to the best of your knowledge and under the penalty of perjury?
Louder. Did Your Honor hear that?
I did not.
He said, yes, ma'am, again.
All right, I need him to, Mr. Banks.
You gotta lean into this microphone. You gotta lean into this microphone right here.
Mr. Banks, I have to be able to hear you or you can't take a plea, okay?
Talk loud.
Talk loud.
You can put your hand down though, but we need to hear you, okay? All right, that was great. If you just keep continuing to do that, I will be able to hear you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am. Just like you're talking to somebody across the street, project your voice.
All right. Did anyone force you to take a plea?
Listen to her question.
Did anyone promise you anything in exchange for taking a plea?
Mr. Banks, are you listening to the judge or trying to read something on the tape? If you listen to the judge, she's asking you yes.
I'm not sure we're gonna be able to take this plea. I don't think. Do you understand what's happening here today, Mr. Banks?
All that's in front of him to read is simply the time served, the case number, his name.
I understand, but there's some hesitation, Mr. McLean. I'm not. Mr. Banks, do you want to take a plea?
Yes. Your Honor, let's put this on the competency calendar or something later.
I don't know if you can go straight to competency, but we're not gonna take this plea right. Yeah, we're not gonna take this plea right now. So let's let you all and Mr. Howard speak to him a little bit further, and we will return to position one. Because it is time served, so I would like to do that if possible, but we're not gonna do it this moment. Perhaps Mr. Howard to speak with him further.
Either more people or the social worker will do that, Your Honor. Thank you.
Okay, we're not resetting him yet, though. I'm hoping we can still get to him today. All right, who do we have next?
Position number 21, this is Mr. Woodard.
And has Mr. Woodard heard his rights?
No, ma'am, you just logged on.
Okay, Mr. Woodard, your case is 23 CR 005705B. In this case, you're charged with theft by shoplifting and criminal trespass. You understand your rights? Oh, you haven't heard your rights. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. Do you understand the rights and how I'm conducting the hearing today?
Yeah, no.
All right, thank you. What is the announcement, Mr. McLean?
Your Honor, this is a negotiated plea.
Okay. All right. I'm trying to understand this note. Defendant was released on this case and he's only served 1 day. Is that correct, Ms. Patty?
That is correct from our notes as well.
Okay. All right. If you give me the very brief factual basis and the offer in this case.
Yes, Your Honor. So on 9/3/2023, officers responded to the Circle K located at 160 Ted Turner Drive in regards to a damage to property incident. The witness, and I do not want to pronounce the last name wrong, but Mrs. Walden Tinseye advised that the defendant came into the store, grabbed a 12-pack of Budweiser and a 42-pack of Bud Light beer and began to walk out of the store, passing all points of sale without paying. The witness told officers that another customer attempted to stop the defendant from exiting, and then the defendant dropped the 2 cases of beer, grabbed a bottle of wine, pushed the customer who was helping, and exited the store. The witness and victim advised that the defendant then kicked the glass door, which damaged the property significantly. As of today, they have not been able to fix the door because the frame and the glass was damaged, so they're having trouble finding all the parts for it. So as it relates to the recommendation for count 1, we're recommending 12 months probation, 30 days to serve credit for time served 1 day, balance probated to stay away from the Circle K located at 160 Ted Turner Drive and an anti-theft course. As for count 2, we're recommending 12 months probation to run concurrent with count 1 and restitution open for 30 days. Nothing further from the state.
All right. I understand he has another hold. However, how much additional time would he have to serve on this particular charge?
14.
14 more
14
days? Okay. Thank you for that math. Was that your understanding of the offer, Mr. McLean? And do you still stipulate the factual basis, ID, and venue?
It is, and we do.
All right, Mr. Woodard, I'm going to ask you some questions to make sure this plea is voluntary. Please raise your right hand. Do you swear and affirm the testimony you give today for the limited purposes of taking a plea to be the truth to the best of your knowledge and under the penalty of perjury? Is that a yes?
Yes.
All right, you can put your hand down. Thank you. All right. Are you under the influence of any drugs or alcohol at this time?
Nothing but cigarettes, man.
I'm sorry, what?
Cigarettes, Newports.
Okay, but are those affecting your ability to understand what's happening today?
Sometimes, you know, we have my mind fogged up.
Okay, I don't know that we can take this plea today, Mr. McLean. It sounds as if your client is saying he's not understanding.
I'm gonna take. I'll take it today.
No, if your mind is foggy, you're
I was saying it ain't fogged up right now.
okay. Let's start again. Let's start again.
over.
Do you fully understand this proceeding today and what we're talking and doing?
Yes, ma'am.
Okay, tell me in your own words what we're doing right now, Mr. Woodard.
What we doing is you give me a plea, making me sure I'm fully understand what you're saying when you give me this plea.
Okay, we're gonna ask some more questions, okay? And did anyone force you to take a plea?
No, ma'am. I'm 33 years old.
Okay, did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you fully understand by taking a plea, it may affect other aspects of your life, such as your open charge, any employment, housing, other things that I may not be able to anticipate. Guilty pleas may affect that. You understand that, Mr. Woodard?
Yes, ma'am.
And you understand you're giving up your right to have the state prove this charge against you, these charges against you beyond a reasonable doubt?
Yes, ma'am.
You understand that?
Yes, ma'am.
And you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you also understand you can't go back to that Circle K?
Yes, ma'am.
And once you're released, you are gonna have to pay for that door you broke. You understand that?
Yes, ma'am.
And you're also gonna have 14 additional days to serve on this particular charge. You understand that?
Yes, ma'am.
All right.
How much I owe you?
I'm sorry.
How much I, no, ma'am.
I'm sorry.
He said, how much do he owe on the door?
Oh, we don't know yet. I think they're gonna have some other restitution hearing. Is that correct, Ms. Body?
That's my understanding.
It says we're gonna hold it open for 30 days. So I guess what will happen is there'll be a separate restitution hearing, Mr. Woodard, where we'll figure out what the amount is owed for the door. Okay?
Your Honor, in more detail, what happens is the state will obtain some documents on the estimate of repair or replacement, and then I will review those documents with him, and he'll either agree to avoid a hearing or have a hearing.
Okay.
And there will be a dollar limit, so he understands the limited nature of the restitution. It won't be above, what is the figure? It won't be above 1,500, and he understands that. I believe that's the correct figure.
All right. So apparently Mr. McLean will give you more information about the restitution. Do you understand that? And based upon the fact that we don't know the exact amount that you may owe today, Mr. Woodard, do you still want to go forward and take this plea?
Yes, ma'am.
Okay. And you are, and we did cover that you have more time to serve on this charge.
Yes, ma'am.
All right. As to the charges of theft by shoplifting and criminal trespass, how do you plead, Mr. Woodard?
Guilty.
I accept your guilty plea. Is there anything additional?
Nothing, Your Honor.
All right. Best of luck to you, sir. That concludes your case at this time.
Thank you, Your Honor.
All right. All right. Who we have next?
Position 2, Mr. Bell. This is
All right.
a-
Have you had a chance to speak to him, Mr. McLean?
Royce Bell, did you finish with him or that's the one I was talking to? Oh, Your Honor, Mr. Royce Bell is the person I was speaking to when we went to another case. So
this is Cameron Bell.
Oh, this is Cameron Bell. What position is that?
It's on probation.
Oh, he's on the
1 and 2.
probation calendar. Okay.
right, so it's a different Mr. Bell.
Okay. Understood.
That's
He's
fine.
Probation,
That's
I'm
fine.
sorry, Judge.
probation 1 and 2. Okay. Mr. Bell, the first case against you is merely the violation itself. The underlying case is 19 CR 001927J, in which you're charged with simple battery, family violence, and simple battery itself, with the offense date of September the 2nd of 2017. Do you understand your rights today?
Yes, ma'am.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Officer Allison, you're still under oath. Please give me your recommendation for the resolution of this case.
Mr. Bell failed to report and he failed to complete a domestic violence intervention program. He has 3 months and 5 days left on his case. Probation is recommended for time served.
And I'm assuming no objection. All right. So essentially, Mr. Bell, the time you've served in the Fulton County Jail will close out your case. And if you don't have other holds, you should be released. All right. All right. Best of luck to you, Mr. Bell. That's the end of your case. Officer Allison, I believe that concludes the entire probation revocation calendar. If you would like to be dismissed for the day, please send any orders for my signature to Ms. Strong.
Okay.
All right.
No.
Okay.
All
Have
right.
a good one. Thank you.
All right. Best of luck. Take care. All right.
This is gonna be positions 10 through 13, Mr. Murray. Is it Murray or Murray? Murray? Mr. Murray?
All right.
That should be
Mr.
through 14, Your Honor.
Okay, because one is what, an FTA?
2 FTAs, Your Honor.
Okay. All right, Mr. Murray, your cases are 21 CR 006160E. In that case, you're charged with simple battery, family violence. The other case is 22 CR 008549D. In that case, you're charged with a DUI, driving while your license was suspended, expired tag, failure to maintain lane, open container, and acquiring a license plate for the purposes of concealing your vehicle's identity. The other cases are FTAs. Do you understand your rights today?
Yes, ma'am.
All right. And the announcement, Mr. McLean?
This is a negotiated plea on the substantive cases and anticipated an offer on the.
On the FTAs, understood. All right, whose case is this for the state? My screen did not.
Ryan Sirocco, Your Honor.
Oh, there you are. Good morning, Mrs. Sirocco. Please proceed.
Good morning. Thank you. For the simple battery family violence, the defense is requesting 12 months probation to serve 30 days, credit for time served 10 days from November 8th, 2021 through November 12th, 2021, and from October 6th to today. Balance probated, a family violence intervention program, 40 hours of community service, no further contact with Chelsea Murray, Chelsea, CHELCI, Murray traditional spelling, and no further contact with Jacob Childers, as well as no firearms. And that's for position 10, Your Honor. Would you like me to proceed to 11?
Well, let's stop for 1 second. Let's see if Miss Murray is on the line or Mr. Childers, and they wish to make any statements. I don't see either party here today, so I'm gonna assume that they're not here. Let's go ahead. I'm gonna let Mr. McLean see if he has any. Was that your understanding of the offer, and do you so stipulate to the 3 elements, Mr. McLean?
Yes, Your Honor, that is our understanding of the offer, and we do stipulate to the 3 elements.
And he would have how many additional days to serve? Is it 10?
Would be
5.
yes, Your Honor, 10.
5 on number 10, and approximately, I think, 9 on number 11. And those would be concurrent. So really, it'd be about 9.
Okay. Is that the same math you have, Mrs. Sirocco?
Your Honor, I have his booking date from the 11th of November, the 8th of November to the 12th, and then from October 6th to today. I believe that brings us to 10 times 2. That's going to be 10 days to serve.
That's what I calculated as well, Mr. McLean. You calculated 5?
My calculation was based on just looking at the offer, Your Honor, the 12 months to serve 30 days, credit for 6. 30 divided by 2 is 15. 15 minus 6 would be, is my math right? 15 minus 6 would be 9.
Okay. So he has at least, let me see.
We're only off by a day of each other.
A day is significant.
A day is very significant.
A day is significant.
I think it should be 9, but I'm not trying to make it not negotiable.
Okay. Let's do that again. I had wrote down 10 earlier, but now I'm questioning my own math. How did I arrive at 10? 20. If he's served 10 days, correct? And he's supposed to serve 30, that would be 20. If he gets the 2-for-1 credit, doesn't that give us 10 days?
Well, Your Honor, on case number 10, which is the SBFB, what I have here is 12 to serve 30, credit for 10. You take the 30 divided by 2, that equals
Okay,
15.
you divide it first.
Equals 5.
Okay.
So the 5 days is smaller than the one that we're talking about now, which is the DUI. And on the DUI,
We haven't gotten to the DUI yet. We're still on the one at position 10. Okay. Do you agree with the 5 days, Mr. Sirocco? So if we divided that 15 minus the 9 served.
Yes, Your Honor.
Okay. I'm bad at this, and every time I get a difference, I did something again and just got 18. So I'm gonna leave that to you all. All right, let's move to position.
I apologize, Judge Williams. Don't mean to cut you off. So what's the exact time so I can put it correctly on the Senate sheet?
Say that again.
What's the correct?
It's still gonna be the 12 months credit for 30 days serve the 30 days. He's gonna serve 30 days and he's getting credit for 10.
Okay,
That's correct.
okay, all
So
right.
that
thank
part
you.
is right. We were just arguing about the calculation and what it turns into. The recommendation itself is still correct. All right. Moving to position number 11, Mrs. Sirocco, please proceed with the recommendation there.
Yes, Your Honor. So the defense here is requesting for count one, it's going to be 12 months to serve 30 days, credit for time served, 6 days in jail from October 6th this month to today, balance probated, as well as an alcohol drug evaluation and any recommended treatment, a risk reduction course, a $600 fine, as well as 120 hours of community service with the violence intervention program. And we also, for count two, 12 months probated, a $500 fine, a 6-month license suspension, concurrent with count one. Count three, a 12-month probation, $120 fine, concurrent with count one. Count four, 12-month probation, $350 fine with concurrent with count one. Count five, a 12-month probation, $250 fine, concurrent with count one. And count six is a 12-month probation, concurrent with count one. Does the defense stipulate the facts, identification, and venue?
We do.
Before we do that, let's calculate. Do you concur that it's going to require an additional 9 days in the Fulton County Jail? I'm working
Yes.
on that, man, as well. Okay. And this case runs concurrent to count 10?
Yes, Your Honor.
Okay. I'm sorry, was Ms. Strong, you were saying something?
No, I wanted to ask Mr. Sirocco, I didn't mean to cut you off. Is it $125 fine for count three, or is it $120 fine for count three?
That's a $125 fine for count
Okay,
three.
thank you.
All right. So, and the 9 days will run concurrent to the time he's serving on position 10, correct?
Yes, Your Honor.
All right. And Mr. McLean, as it pertains to both cases, you do so stipulate to factual basis, ID and FINGU.
Yes, Your Honor.
All right. And those were your understanding of the offer, correct?
Yes, Your Honor.
All right.
Right, now the spelling of Chelsea is with a CI at the end in the accusation itself. It's elsewhere I saw it as a regular spelling, so I'm not sure. I apologize if I didn't hear something before about the correct spelling. But
Are you saying that her name is misspelled and it should be CI?
I have no idea. I just see it. There's 2 different documents with 2 different spellings, and I apologize if I heard the state say which one was correct.
Which one? Do you know?
I believe I believe, Your Honor, it's CHELCI.
That's right.
Okay. All right, so we'll make sure that the order itself bears that name. Mr. Murray, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. I'm gonna ask you some questions first now as it pertains to a case that ends in 6160E, the simple battery case. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking a plea, you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes, ma'am.
And you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand that by pleading guilty to simple battery family violence, there may be other consequences that the court can't anticipate, such as effects on your employment, immigration, or anything of that nature?
Yes, ma'am.
And you feel satisfied with Mr. McLean's representation today?
Yes, ma'am.
All right, as to the charge of simple battery, how do you plead?
Guilty.
And you fully understand the requirements of that guilty plea in that sentence, correct?
Yes, ma'am.
All right, I accept your guilty plea at this time. We're now going to move to case ending in 8549D. All right, you further understand the requirements of this sentence, Mr. Murray? As it pertains to the DUI case?
Yes, ma'am.
Do you understand the requirements of that sentence?
Yes, ma'am.
And you feel confident that Mr. McLean has explained those requirements to you?
Yes, ma'am.
And no one forced you to plead guilty to these particular charges?
No, ma'am.
And you fully understand that by taking a guilty plea to a DUI, that may also have the effect on your employment, immigration, other cases, or other things we can't anticipate?
Yes, ma'am.
As to the charges associated with the case ending in 8549D, Mr. Murray, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything further from the state or defense?
Nothing, Your Honor. Thank you.
No, Your Honor. Thanks.
All right, Mr. Murray, best of luck to you. That concludes your case at this time.
Good to meet you.
Position 14, Mr. Parenti.
Mr. Brent, if I might have a moment on mute, Your Honor.
Sure. I need a moment to find where I am anyway. Mr. McLean, just let me know when you're ready.
Your Honor, we are ready. This is a negotiated plea.
All right, Mr. Parenti, your case is 23 CR 0059994D. In this case, you're charged with obstruction with the offense date of June the 28th of 2023. Do you understand your rights?
Yeah.
All right, and this is a negotiated plea. Mr. Sirocco, if you would please put the offer into the record.
Yes, Your Honor, the offer is going to be time served, 15 days in jail, credit for time served, 8 days for the days he served from October 5th to today.
All right, was that your understanding, Mr. McLean?
Yes, Your Honor.
And do you so stipulate to factual basis, ID, and venue?
We certainly do.
All right, Mr. Parenti, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Do you sufficiently understand this proceeding today?
Yes.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that by taking a guilty plea, it may affect other aspects of your life that the court can't anticipate?
I agree to a plea. You know, time served.
Well, no, that's not my question. My question is, by taking a guilty plea, other things might result. It may affect your ability to get a job, some housing. Sometimes it affects open cases that you have. We can't anticipate always how taking a plea may affect you later. I want to make sure you understand that. Do you understand that?
Yeah.
And you understand you're giving up your right to trial by judge or jury?
Yeah.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
So once I make a decision, I can't go back on it?
You cannot.
I'm all right with it.
I'm sorry, you're what?
I'm all right with it. It's a felony or misdemeanor?
Okay, do you want to speak to Mr. McLean very briefly? Mr. McLean, why don't you, it sounds like he still has a few questions. Why don't you mute us for one moment and answer his questions?
It's got to be your decision. Thank you.
Okay, does he fully, do you feel, did Mr. McLean answer your questions?
Yes.
And do you wish to go forward with taking the plea?
Yeah,
And you understand that you're pleading guilty to type of offense?
yeah,
And you understand that the time you served in the Fulton County Jail will essentially close out this case?
yeah.
All right, Mr. Parenti, as to the charge of obstruction, how do you plead?
I'm guilty.
I accept your guilty plea at this time. Is there anything further from state or defense?
Nothing, Your Honor. Thank you.
No, Your Honor.
All right, best of luck to you, sir. That concludes your case at this time.
All right.
All right. Who do we-
3 through 5, Mr. Diallo.
No, we still need the social.
Still
worker.
need to talk, okay. Go
Yeah,
back.
we need to go back to that. We need the social worker visit eventually.
And then what about Mr. Bell, Royce Bell? Position two?
I need to finish, I've given him some papers to read. I didn't finish up with him, so we're
He said
not
he's
ready.
done.
Well, I'm not through asking him. what he wants. He can-
What about Mr. Banks, position 1? He said he's done.
I'm done. I'm ready. I'm ready.
Okay, can we go on mute for just a second, Your Honor?
Can we take a ACDC position or someone that belongs to Ms. McLeod?
Good morning, Your Honor. I understand there's a conflict. I haven't spoken to him yet. His name is Jarvis, I believe is Montgomery.
Is Mr. Montgomery at courtroom 2?
Mr. Montgomery, judge, is going, let me see, I'm checking to see what floor he's on.
So he's not there. When he comes on, I guess we'll put him in a breakout with Ms. McLeod.
That would be fine, Your Honor. Thank you.
Okay. Well, I tried. Is that your only position today, Ms. McLeod?
Yes, Your Honor.
Oh, it did not work out again.
That's just fine for me. I was supposed to have a jury trial today, which did not go forward, so.
All right, well, we're hoping.
I can sit and wait until Mr. Montgomery comes on.
I apologize. I don't see a Montgomery on the calendar. Ms. McLeod, do you have his case number?
17, I was told, I believe it's 17.
Let me look.
Right, Riley Montgomery. That's
Okay, got it. Thank you.
Okay. And I'm assuming all the position, Mr. McLean is busy, so we can't, is there another position that belongs to Mr. Howard, perhaps?
Yes, Your Honor, good morning at the ACDC. The
Good
ladies
morning.
that's in front of you. And they need to hear their rights.
All right. Is Mr. Howard at courtroom 2 and ready to proceed or no? I don't think Mr. Howard is there. We may be at a brief pause. I will still give you your rights. All right, all ladies at ACDC, good morning.
I'm sorry, Judge. Derek Howard is actually on the phone. You ready? Okay, he's ready.
Okay. Good morning, all ladies at ACDC. I'm Judge Melanie Williams. This is the state all-purpose calendar in the state court of Fulton County, Georgia. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding today. And I believe Mr. Howard is here to represent several of you, or Mr. McLean is here to represent you as well. This particular proceeding is being broadcast over the internet as a live stream. That means that any member of the public can log on and watch it. It's also being recorded. When I ask you if you understand your rights, those are the rights to which I'm referring. I'm asking if you understand your rights to an attorney, to remain silent, and how I'm conducting the hearing today. All right, who do we have first at ACDC?
Ms. Donna Holmes, position number 7, please come up and have a seat.
All right, and the announcement, Mr. Howard, for this position? All right, Ms. Hogs, your case is 23 CR 005848E. In this case, you're charged with battery. Do you understand your rights? I'm assuming you're saying yes, she's muted. Mr. Howard, what is the announcement?
Judge, this is gonna be a not guilty, and we can do a waiver of arraignment and ask the court to address bond.
Okay, are you going to enter the formal waiver today, or would you like me to arraign her at this time?
No, Judge, I'll send over the written waiver to Mr. Holmes when we get it.
All right, thank you. And we'll take up the bond hearing. Let me take a note really quickly. Let me enter today. Okay, So essentially, Ms. Hogg, what's happened is your attorney has waived arraigning the case. That means your case will proceed forward as if it's going to trial. All right, and now we're gonna address your bond today. Before we do, is anybody, Ms. Tyson, can I have this defendant's history, please?
Your Honor. 1 second.
Okay, now this is fine. We get scheduled by some other judge. It doesn't not scheduled for trial, so we can definitely.
Right, Ms. Oh, she has 53 arrest cycles beginning in 1986. History within last 10 years. She has a misdemeanor conviction for theft by shoplifting out of Fulton County from 2015. She has a felony conviction out of Fulton County for burglary in the first degree from 2015. She has a misdemeanor conviction out of Cobb County for theft of lost, mislaid property. It's from 2017. It looks like she has a possible another open case for theft by shoplifting. Arrest date was November 4th of 2021. No dispositions listed on the GCIC. She has 1 FTA from 2019, and she has a total of she has 1 violation of probation out of Fulton County. That's from 2021. Nothing to add, Your Honor. I'm sorry. She does have a hold also out of South Fulton.
Okay. All right. Ms. Nemini, please proceed with your recommendation for bond, and please tell me, what is the current bond?
There's 1,500 surety bond, Your Honor.
All right. Did I set that bond? We don't know.
I don't
All
have
right.
that.
No. All right. Ms. Nimini, please proceed with the factual basis as well as your recommendations.
Yes, Your Honor. This incident happened September 29th of 2023 at 1296 Murphy Avenue, Southwest. Officers arrived and they spoke with the witnesses on the scene. And they went to the suspect or the defendant and detained her. With the interview, they spoke with Ms. Bemestein Clemens, who is the victim, who met with the defendant and told her that she did not want to be bothered. And that's when the defendant threw an open hand slap, striking the victim, Ms. Bemestein Clemens. And that is when one of the witnesses stated that that's when Ms. Bemestein stood up in an attempt to defend herself. And that's when the defendant grabbed her by her arm, threw her into the ground, and that's when one of the side witnesses stated that she went over to help Ms. Bemestein and try to separate both parties. But that's when the defendant walked over to Ms. Bemestein and threw her back on the ground. And then a second witness, a second witness confirmed this. And again, she slapped her and knocked her to the ground again. Ms. Bemestein sustained a cut to the left hand, a cut to her right shoulder, and a swelling left cheek, and that was documented on officer's body-worn camera. Judge Law was the one who set this bond, Your Honor. Just based on the facts, Your Honor, and based on defendant's criminal history, she has a lot of theft by shoplifting, and she has a couple of simple battery arrests, Your Honor. The state does believe that the 1,500 surety is more than reasonable, considering that she is a habitual offender. And I also have 56 cycles instead of 53. So the state is asking that bond remains as set, Your Honor.
And put your offer, there was an offer, please put that offer onto the record as well.
Yes, Your Honor. The offer was 12 months to serve 90 days, credit for time served 13 days, coming from that day that she was arrested, September 29th of this year, 12 weeks of anger management, 20 hours of community service, no further contact with Ms. Bernstein Clemens, and a stay away from the 1296 Murphy Avenue, Southwest, Your Honor.
All right, thank you. And Mr. Howard, your client rejects that offer.
That's correct, Judge.
All right, and your recommendation as to her bond?
Judge, we're asking the court to consider reducing this to a signature bond. Ms. Ms. Holmes obviously has not been able to make the $1,500 bond, given her financial state. She is working. She is working, Judge, but she makes a limited amount of income working for Aspect Security as a security guard. She has jobs with them as they have it available. She's a lifelong Georgia resident. She's been in the metro Atlanta area for about 20 years. Prior to that, she went to high school in the early years in Augusta, Georgia. But she has family that's locally, tied to the community as well as her. She's been at her current address for the past 2 years. And Judge, she denies that she was the initial aggressor in this case. We believe there's things that happened prior to what was reported by the state that impact her guilt or innocence. There are other people who will be able to speak to that. So she's denying that she was the aggressor in this case, which is why we're not accepting the offer this time. Judge, I didn't hear a recent history of violence. I heard the most recent arrests appear to be theft related and things of that nature. The South Fulton hold is related to a theft charge, Judge. But we would ask the court, given the amount of time she's been in custody, which is 13 days at this point, to allow her to contest these charges outside the Fulton County Jail. We'd ask that it be reduced to a signature bond and understand that she'll have to go to South Fulton.
What is the name? You said the South Fulton hold is a shoplifting?
Yes.
I'm sorry, Ms. Tyson, can you give me the history in the last 4 years, last 3 years? I'm sorry. I know I know you may not have separated that way, but
no, that's okay. You said 3 years, right?
That's 3.
Okay. She has one violation of probation. That was for a theft by shoplifting case, a felony theft by shoplifting case. That was in 2021. You just want convictions, or do you want like arrests that might have been?
Just the history, anything that happened.
Okay, she has out of Atlanta, a misdemeanor possession and use of drug-related objects, 2020, that case was dismissed. One FTA in 2019. Yep, and that's it. Yeah, it's within the last 3 years.
Okay. That's good. All right, what I'm gonna do is I'm gonna reduce her, I'm not gonna give her a signature bond, but I will reduce the amount of the bond to a $750 surety bond. All right, and we will reset her case for the notice for trial.
Excuse me, Your Honor.
Okay, I don't think you should speak to me. I think the best thing for you to do is speak to Mr. Howard. All right?
Okay, Mr. Howard.
Well, we're not on the Zoom. I'll have to call over once we're done with the other ladies, and you and I can talk privately. So we can't talk over the Zoom. All right.
Mr. Howard, please, can you please come on, because I need to talk to you, Judge. I can't make that bond. I get put out. My lease is up on the 16th. I'm just trying to move, ma'am. She ran up on me, Your Honor. I promise you. I've been at property 2 years. I have not bothered anybody. Nobody, ma'am. I have not even been in trouble. Like she said, that my last thing was probation shoplifting a while back. I don't get in trouble, no, ma'am. I'm in the program. I can't afford to lose my house, ma'am. I'm going to be on 55 next month. If I get time, I'll take probation. I'll take 2 year probation. Now I just need to get out and get out.
I hear you. Hold on, ma'am. Let's hold it. All right. The judge here.
I have to. I understand that. One question, Mr. Howard. Excuse me.
Please, ma'am.
I'm not speaking to you, Ms. Hogan. Let me speak to Mr. Howard very quickly.
Yes, ma'am.
The only issue as it pertained to the state's offer, Mr. Howard, was the amount of jail time.
No, I didn't say that. No.
Yes.
I'm asking that. Was there
Well, Judge, no, that wasn't the only issue. But without getting too much in that, my client discussions, Judge, I would just say that wasn't the only issue.
Okay.
But
yeah,
I was going to ask if you, one second, Ms. Hall. I was going to ask if you wanted to consider a non-negotiated plea, Mr. Howard, or you don't think that's appropriate at this time.
Well, Ms. Holmes and I discussed that, Judge, but it
yes,
like maybe she wants to.
Wait, Ms. Holmes, please be quiet. I cannot hear Mr. Howard.
Yes,
Mr. Howard, I'm sorry. Go ahead.
So Judge, again, let's put her to the end and I'll talk with her a little bit more and see if she wants to reconsider the options we discussed yesterday. So if we could just come back and I can talk with her a little bit more in detail, Judge.
Okay, we'll come, Ms. Hall, we're gonna come back to your case, okay? Let me put a note.
Thank you.
Position number 20, Stephen Valentine.
I thought we was doing the female.
Your Honor, the state does have an announcement on position 20. However, we would ask that it be placed last on the calendar due to the nature of the charge.
Is Mr. Valentine in medical? Is that Mr. Valentine?
Yes, ma'am.
Honor, that's Mr.
Okay, can we, Mr. Valentine is by himself, I believe. Can we put courtroom 2? Oh, we can't do that because Mr. McLean is there.
We can do a breakout and explain to her.
Your Honor, this.
One
you don't
second,
need to
Ms.
do-
Falk, 1 second, Ms. Falk. I already know what you're gonna say. What I'm trying to do is make sure the courtroom is clear, but the problem is there's somebody with an iPhone who has walked to medical. And I know the state is gonna object to a breakout because of the nature of the charge here. What I would suggest, I guess we don't have a choice but to come back to Mr. Valentine.
Judge Williams, I can make this real quick. I promise.
Okay.
That was not what I was going to say. This case was accepted for transfer by the DA's office based on the fact that it's a recidivist charge. That's it.
Oh, well, you're correct, Ms. Falk. You got me. Okay, Mr. Valentine, essentially what's gonna happen to this case, I am not gonna read the charges today, but you can speak with your attorney about the charges you are currently facing at this time. Your case has been upgraded to a felony and will be transferred. The DA's office has already accepted it. All right? So there's nothing further that we're going to be able to do with it today, as it's now beyond my jurisdiction or my reach. But I'm sure Mr. McLean or Mr. Howard will speak with you at some point about how your case is progressing. I know you have questions. I don't want you to say something that if you have a question just about the transfer, can we unmute him?
No. We're unmuted, Your Honor.
Not-
I'm
Ms.
sorry.
Wa- I know you want to speak, but I don't recommend that, Mr.
Well, I
Valentine.
want to, that's my right, though.
I know, but
you can't keep me from speaking, Judge.
I actually can, but give me one moment. Mr. McLean, what would you like to tell me?
I'll go visit him as soon as court's over with and tell him everything that's going on.
Okay, so your attorney is on his way to speak with you when we finish court, Mr. Valentine. What do you want to tell me? Don't talk about, let me give you some instructions first. Do not talk about the facts of your case. The state is listening and ready, willing, and able to add additional charges based upon anything you might tell me. Okay, so do not tell me about your case.
Okay.
Do you have a question
My
about the
statement is,
transfer?
I have a question concerning the recidivist. Doesn't it have to be 3 times?
I can explain that.
Okay, Mr. McLean is gonna come and explain it to you. I cannot give you any legal explanations, okay? Do you have another question just about the transfer?
Why is this?
It's going to be fairly simple and straightforward. If I have time, I'll even get a document to show you. I'll tell you about what I've been told about recidivism, and I'll explain the concept and how it applies to these facts. It'll be fine. I'll come this afternoon as soon as we're through with court.
Okay, so your attorney is on his way as soon as he can and as soon as it's practical, okay?
Mr. McLean, he's on 4 North. He's not on medical. We just had to bring him down. He's on 4 North.
Understood. Thank you.
All right.
All right, Mr. Valentine, I know you're frustrated and don't understand exactly what has taken place today, but Mr. McLean is gonna come and further explain it to you, okay? And I do wish you best of luck at this time.
Positions 3 through 5, Mr. Diallo.
Yara, I had put this down for a social worker visit, and that apparently has happened, and he's spoken to a social worker either in person or on the phone, and I think we're ready to go forward.
All right, thank you. That's a good announcement. Mr. Diallo, you have 2 cases today, 3, but one is just simply an FTA. So the cases are 23 CR 005844D in which you're charged with simple battery in a public transit station. And the other case is 22 CR 008561D, in which you're charged with criminal trespass. You understand your rights?
Yes.
All right, thank you. The announcement is that it's a negotiated plea. Is that
Yes, Your
correct?
Honor. 3 and 5 are negotiated, and we anticipate a null process on 4.
All right, Ms. Nemini, if you would put the offer onto the record for me.
Yes, Your Honor. For position 3, Your Honor, the state is requesting a 12 months probation, 28 days, credit for time served 14 days. Defendant has been in custody since September 29th. No further contact with Lance Brook, stay away from the Peachtree Center MARTA station, considering that the victim is an employee at that specific MARTA location. For position, sorry. Yes, for the next position, Your Honor, that will also be the 12 months probation, 28 days, credit for time served 14 days, balance probated, non-reporting, stay away from 3066 Barksdale Circle, East Point, no further contact with Alpha Diallo, the same last name, concurrent with the 23 CR 005A44D. The state was able to speak to the family member, and I do know that the mother wants to have contact. However, the state was not able to speak with the father. So we are going to keep that no further contact with Mr. Alpha Diallo.
All right, let's sound for both victims first. Is Lance Brooks present? Okay, I don't see or hear from Mr. Lance Brooks. And it's Alpha Diallo present.
Yes.
Your Honor, I assume that if they have the same middle name, it would be junior and senior, but
That's
often.
is that person a minor?
No, Your Honor. Alpha Diallo, the victim alleged, is the father, I believe.
Oh, the father. That's what I'm. All right. Is the father present?
Family is present, but
All right.
not
Is
the father.
the father is the only person that we need to hear from today. He's not present. Does he wish to make a statement? Okay.
No, but the name is wrong.
Okay. What is the correct name?
Aliou Diallo, ALIOU. He's not a junior.
Okay.
All right. Understood. Thank you.
And
All
the
right.
and the spelling of Diallo is not with the A, correct?
It's D-I-A-L.
Diollo, that's what I have, Your Honor.
Okay.
DIALLO.
Okay. All right. So your client wishes to go forward and take the plea, Mr. McLean, correct?
That is correct.
And that was your understanding of the offer, and you so stipulate the factual basis, ID, and venue in this case.
It is our understanding, and we do so stipulate.
All right, let's first take up the case of 23 CR 005844D. Mr. Diallo, are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand by taking a guilty plea, you give up your right to trial by judge or jury?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment or immigration or things that I may not be able to anticipate?
Yes.
And you further understand the requirements that you cannot go back to the Peachtree Center MARTA station, and you can't have any contact with Mr. Brooks. Otherwise, the time you served in Fulton County Jail will close that case.
Yes.
All right, as to the charge of simple battery in a public transit vehicle or station, how do you plead?
Guilty.
All right, as it pertains to case 8561D, the criminal trespass, you understand that you can't go back to the address on Barksdale Circle?
Yes.
And you understand you can't have any contact with the victim in that case?
Yes.
And you further understand that The time you served in the Fulton County Jail will otherwise close out that case?
Yes.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional, Mr. McLean or Ms. Nimini?
Nothing, Your Honor. Thank you.
I have a question. Ms. Nimini, just to confirm, these are balance suspended, not probated, correct? Because there are no conditions.
It's balance probated with non-reporting
What is the probation?
per Ms. Falk's instructions.
And Your Honor, just to explain, we've had some issues where we have done
They've
a
gone back
balance
to the location.
correct, where we've done
Yeah.
balance suspended, and then the argument is the conditions no longer apply. So we're doing
Yeah.
reporting.
Understood. I've seen it done both ways and I can understand. So they're trying to make the stay away applicable for the whole time. All right. Understood. I believe that will close the case at this time. Best of luck to you, sir.
Can I ask a question?
I don't think you should. The best thing to do is to ask Mr. McLean.
All right.
You'll be released today if you have nothing else.
I just wanted to,
I'm gonna need to address.
the good man.
Yeah. Can we go on mute for a second? Right, what you need to do? We're done with court, just to get his contact, best mailing address for a friend. So
Is there anything additional, Mr. McLean, as it pertains to this case?
nothing additional, Your Honor.
All right, best of luck to you, sir. Can we move to the next position, please?
Going back to position 2, Mr. Bell. Royce.
All right, and he's already indicated that he understands his right. Mr. McLean, the announcement?
I don't believe this is a guilty plea today, Your Honor.
No. Yeah. If I can I speak for a moment?
No. All right, so Mr. McLean, are we arraigning this case?
Would you like to waive the formal reading of the accusation sheets, which I can give you a copy of? Those are the actual pages with the accusations. That would save the judge the time of reading them out loud to you line by line. There's several pages that take several minutes, but you're entitled to that. But if you would like for me to hand you copies of those same accusation sheets, then you could say, we waive the formal reading of the accusations. The judge would then tell you what the maximum punishment is, and the judge would tell you to watch out for your trial date, and that would be called an arraignment. Or do you want to do an arraignment today?
Arraignment.
An arraignment is when you're
Why
told.
don't you mute him? Why don't you mute that courtroom too? It sounds like you all are not quite ready. Do we expect to be heard on bond too?
Bond reinstated.
Okay.
Already made the bond, why can't you?
All right. That's fine. You can ask for reinstatement of bond. Yes, Your Honor, he's going to ask for reinstatement of his bond.
And I like to try, I was just asking her if she could.
Wait, no, hold on one second. Mr. McLean, I need you to tell me. I don't want him to tell me. I don't want him to say something. What is the announcement today?
Well, I'm available to give him copies of the accusations if he feels that suffices for reading them. And if he wishes for me to then waive the formal reading of the accusations, the arraignment would, if the court needs to do an arraignment, it would consist of telling him the maximum punishments and then to watch out for his court dates and don't miss.
All right.
Your Honor, I believe he wants to address bond.
Okay, do you want to address bond today, Mr. McLean?
Well, Your Honor, I'd like to talk with him about that further. He was outsourced and came in this morning, so I'd like to ask him about bond factors.
Okay, why don't you take a moment and then give me your announcement for how we're gonna proceed with this case?
Thank you, Your Honor. Let's go.
Thank you.
Going back to position 1, Mr. Banks. Come on, Mr. Banks.
Okay.
I don't think we were ready to go back to that. We're supposed to do that as someone was supposed to come speak to Mr. Banks, correct?
Yeah, they already spoke to him, Judge.
Right.
Okay.
This is going to be competency calendar reset, Your Honor.
Okay, are we ordering something as part of that reset?
Yes, Your Honor.
Okay. Mr. Howard, where are we setting him? How far out?
Judge, I don't know how, whatever the first available would be. We're gonna try to come up with something, obviously, to try to transition him out of jail, but we won't be able to proceed with a plea or anything of that nature today.
Okay, Ms. Strong, what's my first available competency date?
One moment, please. Is he inquiring about getting more time to get paperwork and stuff, or just resetting him to the next one that,
What I'm thinking is that they're gonna have to find him some services, some wraparound services. Is that correct, Mr. Howard?
Yes,
Right.
Judge. So we don't want to, belabor his time here, but we just can't proceed on it.
But have a seat.
With the plea.
What about, are we ordering an eval as well, or no?
Judge, I would prefer not to.
I know you would, but if there's a other concern, how would we address? I guess we could put it on competency, but typically, I think he has to be on the eval track to get onto the competency calendar.
okay, so October the 26th.
So, but no eval is what you're saying, Mr. Howard?
If the court is going to require that, we'll do it, but my thought is we're going to be able to do something. We're going to try to figure out a way without him having to wait for that.
Okay.
And actually, Judge, if Ms. Burgess is on the line, I'm going to talk to her a little bit further. We may be prepared to offer a different option today, Judge.
Okay,
So,
we'll come back to this again.
Yes.
Can we come back? Let's come back to this again. Okay. All right. And I'm sure the state will have to weigh in as well, Ms. Falk, as it pertains to that one.
Understood.
Okay. So maybe we just can Mr. Banks, we perhaps just talk about him when we talk about competency?
Yes,
Let's add him to that competency list.
I think that would be the best way to address it.
That's really the only way I can think of, to be honest. All right. Can we take another position at the jail?
Position 2, we're going back to, are you guys done with Mr. Bell? Right?
On Royceville, it is speaking about bond factors
Yeah,
to
we're
present
done.
to the court.
So he still got to talk to us.
Okay, the only person that's left, Judge, is position 2, Mr. Bell.
Okay. We still got some ACDC position.
He's ready, Judge. Come on, Mr. No.
Mr. Bell has to speak to Mr. McLean, and I know he hasn't done that yet. So why don't we mute at courtroom 2 for a moment?
Sitting before you, Your Honor, is position 9, Ms. Loretta McCullough.
All right, is that Mr. Howard's position by any chance?
Yes, Your Honor.
Oh,
All these
good.
ladies over here are Mr. Howard's.
Wonderful, thank you. Ms. McCullough, your case is 22 CR 002758Y. You're charged with theft by deception. Do you understand your rights today?
Yes.
All right, and the announcement for this one, Mr. Howard?
Judge, Ms. McCullough is going to be a not guilty plea, and we're asking to address bond with her today.
Okay. All right, can I have her history, please, Ms. Tyson?
Yes, Your Honor. Let's see. This is Ms. McCullough, right?
Yes.
Okay. Ms. McCullough, she has 8 arrest cycles beginning in 2012. She has a misdemeanor conviction out of Clayton County for giving false name. Let's see. In 2014, she took a NOLO plea on that case. She has, let's see, looks like 1 FTA from, one moment. 1 FTA from 2014. Her last arrest I'm sorry, let's see. And she also has a misdemeanor conviction out of DeKalb County for two counts of family violence, first offense, and one count of simple battery, false report of a crime, and disorderly conduct. And that's from December 2019. She received 24 months probation on that case. And it looks like, yep, her last arrest was the case that's on the calendar, the theft by deception, May 4th of 2022.
Okay.
Nothing to add, Your Honor.
Thank you, Ms. Tyson. Mrs. Sirocco, please proceed. Give me the factual basis as well as your recommendation.
Yes, Your Honor. In this case, the victim, Madison Owens, traditional spelling, answered an advertisement posted on Craigslist.org for a Volkswagen sedan offered for sale. Ms. Owens contacted the seller and continued their conversation by text through Craigslist. Ms. Owens conversed with and transferred funds to the seller, the defendant, while she was at her apartment at 711 Techwood Drive, Northwest Atlanta. Ms. Owens sent the defendant an initial deposit payment of $150, followed by several payments over the next 2 days through Zelle and Cash App, totaling $1,500. Each of these payments were made to the Cash App account that the defendant gave her, $LMCALLA88. After sending the money, Ms. Owens did not hear back from the defendant and never received the sedan. It should be noted, excuse me, that the victim recommended that the defendant perform community service and pay fines to this date. She hasn't received her deposit or any other payments back. And Your Honor, the defense has 9 arrest cycles in Georgia. This is the defendant's 3rd arrest for some form of theft. She was arrested in 2012 for theft by shoplifting, for which time expired, and currently has another open case in Fulton for theft by receiving stolen property, for which she was arrested in 2023 and is in custody on a $5,000 surety bond. She presents a risk of reoffense here, and for these reasons, Your Honor, the state recommends 12 months probation to serve 30 days with credits for time served, 12 days, the dates for which are May 4th through May 5th of 2022 and October 3rd, 2023 to today, balance probated, as well as an anti-theft course, $1,500 restitution to Madison Owens, as well as a no further contact with Madison Owens. And at this time, the state would like to sound for the victim, although I do not see her on the Zoom call.
All right, I don't either. Is Ms. Owens present, wishes to make a statement? Okay. All right. Mr. Howard, you're muted, but I'm assuming your client rejects that offer. And you are requesting a signature bond, I'm sure, but please proceed.
That is correct, Judge. In short, Ms. McCullough, this isn't her, Judge. She lost, or not lost, someone stole her items, her purse and other items from her home back in 2021. Her ID and other personal effects were included in that theft. And she is completely unaware of any of these allegations or any of the parties mentioned, even in the affidavit and the incident reports that I've read, Judge. And we believe that she's the victim of identity theft. It's interesting that the alleged victim indicated that they Cash App or Zelle money to someone. Ms. McCullough doesn't have a bank account or anything of that nature, so you would need that to set up Cash App or Zelle. She does not know the person that the incident report names as associated, or Brian Shannon or someone along those lines, no one that she knows or is familiar with. And it appears that someone presented a picture of an ID to the alleged victim. Now, they didn't show their face. They presented a picture of an ID, which would have been her ID, which is why her name is associated with this. But Judge, she is completely adamant that she is not the person involved with this. And we believe that someone, a very creative thief, figured out a way to extort money from this alleged victim, but it was not Ms. McCullough. Judge, she's a lifelong Georgia resident. She attended Banneker High School right here in the Metro Atlanta area. She's been working full-time at the Circle K in Union City for the past 2 years. Her time in custody, obviously, that's potentially impacting her job. She does believe she'll be able to return, given her relationship with them. And she does have 4 minor children ranging in ages from 10 years old to 6 years old that are with family members right now. And of course, she's concerned about being able to get back to her children as well. Judge, given that this is an allegation of money being stolen and she's done 13 days even without a determination of guilt in this instance, Judge, we'd ask that this be converted to a signature bond so that she won't continue to be held on this. Because again, we believe that she's a victim of identity theft in this case, and it's not a crime of violence. It's not a crime of it's alleging that $1,500 was taken from someone, and we believe the time she's been in custody is sufficient to address that pre-trial. So we'd ask the court to convert that $7,500 bond to a signature bond.
Okay. And does she have other holds? No? Is it
Yes,
only-
Judge, she has a felony matter. She has a court date on the 26th for that.
Okay, and current bond is 7,500 surety
Yes, Judge.
with the conditions that she have no contact with the victim?
Not sure, but I'm certain that would not be an issue. She doesn't know the person.
All right, defendant will receive a $7,500 signature bond through the jail. She's to have absolutely no contact with the alleged victim in this case. Additionally, she's to have no alcohol, drugs, or weapons as a condition of that SOV.
Thank you, Judge.
Ms. Falk, you want to say something? Go ahead. You're muted.
There is also a stay away from 711 Techwood Drive and all Georgia Tech property per the original order in 2022.
All right, so we'll reactivate those conditions as well. All right, Mr. McCullough, best of luck to you. This case is now concluded at this time. All right, who do we have next?
Position 18 and 19, Ms. Candace St. Gillis.
Okay, and position 18 is the FTA itself. Ms. St. Gilles, your case is 22 CR 008057H. You're charged with simple battery family violence with the offense date of November the 29th of 2022. You understand your rights?
Yes, ma'am.
All right, and the announcement, Mr. Howard?
Judge, this is going to be a negotiated plea.
All right. All right, Ms. Body, please proceed. Please put the recommendation onto the offer. And because of the nature of this case, will you please give me a brief factual basis?
Yes, Your Honor. So our state's recommendation would be 12 months probation, 120 days, credit for time served 62 days, balance probated, family violence intervention, 20 hours of community service, no further contact with Mr. Owen St. Gilles, and to stay away from 670 Eleanor Place Northwest, as well as an ADET. The facts as they relate to the case before us, on November 29th, 2022, officers were dispatched to the location that I previously stated in reference to a domestic dispute. Officers spoke with Mr. Owen St. Gilles, who stated that the defendant, his wife, was physically violent towards him by slapping him on the right side of the face, punching him with a closed fist in his mid-torso, and kicking him in his leg. Mr. St. Gilles stated that his wife was very intoxicated throughout the day, and when officers asked Ms. St. Gilles if she had been drinking, she responded yes. The victim recorded everything on the cell phone, and in the video, officers were able to hear and see the physical dispute. We've spoken with the victim, who stated that he did file for divorce, and the divorce was finalized on August 1st of 2023, and that he was given full custody of both of the children. There was a TPO granted for them and the 2 children as well. And he says that this was not the first instance of this. However, they've been going through this for years. As it relates to her criminal history, she does have a reckless conduct conviction. That's case number 20 CR 001433H, in which she was sentenced to 12 months, credit for time served 2 days, and also balance probated in parenting classes. She also has an open battery, family violence, and cruelty that I could not find a case number on. And then again, she did fail to appear on this charge earlier.
All right. Mr. Howard, is that your understanding of the offer as it pertains to this case? And do you stipulate the factual basis, ID, and venue?
You do, Judge.
All right. All right, ma'am, I'm gonna place you under oath and ask you some questions to make sure this is a voluntary plea, okay? Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Before we begin, I forgot to sound for the victim in this case. Is Mr. Owen St. Gelais present and wishes to make a statement? All right, hearing and seeing none. Are you under the influence of any drugs or alcohol at this time?
No.
Do you sufficiently understand this proceeding today?
Yes.
Are you satisfied with Mr. Howard's representation of you today?
Yes.
And do you understand that by taking a guilty plea, you're giving up your right to a trial by judge or jury?
Yes.
And you're also giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand that taking a guilty plea may affect other aspects of your life that I may not be able to anticipate, such as employment or immigration?
Yes.
And do you understand the requirements of the sentence? You need to complete a family violence intervention course, 20 hours of community service, and have no contact with Mr. Owen St. Gelais, as well as stay away from the address on Eleanor Place. And there's also an evaluation that you need to undergo. Do you understand all of that?
Yes.
All right. And I believe I asked all these questions as it pertains to the charge of simple battery family violence. How do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or the defense as it pertains to this case?
Yes, Judge, just one matter that I just need to clarify with Ms. St. Gelais in light of the state assertions this morning. We had discussed allowing third-party transfer of the children. She was fine with the stay away and no contact with her ex-husband, but she was asking to be able to have third-party transfer of the children. So I just want to clarify, is there a Superior Court divorce decree? Or you said there was a TPO in which she is not allowed to have contact with the children? Is that my understanding, Ms. Body?
So my understanding was that the TPO was filed before the divorce was finalized in August of 2023. So I believe right now it's just the divorce and the full custody of the two children with Mr. St. Gelais. So I do believe that TPO is not applicable around.
Okay, all right. So if it's not, we've just asked that for third-party transfer of the children so she can maintain obviously a relationship with the children.
And the state would agree with that.
The state has no objections. All right, we will allow Ms. St. Gelais to have third-party transfer of the children, which means she needs to coordinate that through someone else, not by making any contact directly with Mr. St. Gelais.
And Judge, finally, if we could ask that she be allowed to either go to non-reporting or termination upon completion of all the requirements and conditions, if she's able to get it done prior to 12 months.
Okay, Mrs. Falk has come on, so I'm assuming there's a concern from the state.
Well, only one small thing, Your Honor, because there is a actual divorce decree with conditions attached. I don't want to order anything that would complicate the already existing order. So what I would like to say is instead of third-party contact, just visitation as directed in the child custody agreement, because if there is a custody, I don't know what the conditions are of the custody agreement, but there's already a legal document enforced.
Even still, the problem might be that she does have visitation. I agree with that, Ms. Falk, and I don't have any objection to that, but I still, whatever visitation is given, it still needs to be coordinated through a third party, because that divorce decree may not say that.
Correct. We could put third party contact
as outlined in her divorce decree.
As outlined in her divorce decree.
Okay. Do you have any objection to that, Mr. Howard?
So, Mr. you okay with that? Basically, follow the terms of the divorce decree, but third party contact, if the divorce decree allows contact with the children or does it prohibit you from having any contact with them in any way, the court is saying that we would just sort of mention the language in this divorce decree because it would control. So you're fine with that?
Yeah. Okay. Yes, absolutely.
All right.
Okay, so it's gonna say she's allowed to have third party to coordinate a third party transfer of her children as visitation is allowed in her divorce decree.
Okay.
All right. And you asked about it going non-reporting. Once she's completed the requirements, I will allow it to go non-reporting once she's completed the class and the service.
Thank you, Judge.
All right.
All right.
Anything additional?
Nothing further for this case, Judge.
Anything further, Ms. Body?
No, Your Honor, nothing from the state.
All right. Best of luck to Ms. St. Julie. That concludes your case.
Okay, thank you. I'm sorry, Judge, going back to position 2, Mr. Bell, Royce.
Are we ready?
Yeah, sure.
Are we ready for real this time? Okay. What is the announcement? What's the announcement?
Your Honor, this is a bond request. He had a bond before of several $1,000s, and he made that bond. Since then, he has some other bonds on other matters. He would like to reinstate the bond that he had, Your Honor, so as to cause him not to have to pay additional fees. So in essence, in a sense, I'm asking
Before
for-
we get to that, am I arraigning his case?
Oh,
That
I'm
was
sorry.
our first question from last time.
I'm sorry. I believe that he would be willing, I'm thinking he would be willing to allow me to waive the formal reading of his accusation sheets. We have copies and I can provide him with copies of those so that you would see exactly what the accusations say. So with a formal waiver of the formal reading of the accusation sheets, all that would be left for an arraignment would be understanding the maximum punishment.
Okay, we're gonna go for it. I'm gonna arraign his case because what you're gonna do, sir, is once I read the charge, you're gonna plead not guilty. And I'll let you decide. Do you waive a formal reading of this accusation?
No, I don't.
You do not waive a formal reading?
No.
Okay, that's gonna take us a moment. Give me a second to pull up Odyssey. Everyone bear with me. And while I'm getting ready to arraign his case, Mr. McLean, you do have the right to waive the arraignment entirely. Would you like to do that and enter a formal waiver of the arraignment?
I don't believe I can do that, Your Honor. Thank you.
We continue to try these things. All right, let me get logged in. In the meantime, I understand that he's saying he wants a bond reinstated, but what was the procedural posture? What happened whereby the bond was surrendered?
I believe he had other things, and I don't have the
Was it he had received a pretrial bond that was surrendered? Is that what happened?
I don't see the word surrender on, sometimes these booking sheets actually run on so much that you can tell that they didn't finish printing it. But in this particular case, he says it's a bonding company that surrendered it.
A bench warrant was issued on June 1st, 2023.
Okay. Well, thank you, Ms. Faulk. Okay.
Now what I'm looking at is his booking sheet is there's an $8,000 bond that is now set on the failure to appear on the associated FTA. So what he's saying today is, Your Honor, on that $8,000, he'll be asking for a signature bond on that. And that would take care of this case.
I understand what he's asking, but Ms. McLean, what are you, remember, you're in charge here. What are you asking me to do today?
Right, I'm simply asking the court to consider a signature bond on that 8,000, and I'll give the court some factors about.
Okay, give me a moment. I'm still stuck on this formal reading. Give me a moment.
I understand.
Odyssey is doing what Odyssey loves to do.
And Your Honor, the state will request that the bond remain as said.
Ms. Nimini, please. You see, I'm struggling. Give me one moment and then we'll go back to that bond. Okay.
My brother still on the other house too.
Okay, he is position 2 on the regular state of purpose.
3031.
It is loading. All right. All right, we have quite a few accusations to read. Mr. Bell, please pay attention.
Yes, ma'am.
All right, let's begin with oh, it's loading so slowly. Hold on. Oh, it's loading so slowly. It's coming, it's trying. Have to give me one more moment. Odyssey is now frozen. Give me a moment. Let me close it out and start again.
Oh, Your Honor, I hear that we can just pass this. I'm actually handing him printed copies of each accusation page, and he says now that we can waive the formal reading of those.
All right, sir, we're gonna waive the formal reading. All right. I appreciate that waiver. I was coming. Odyssey was attempting to show me what it is. I made it to the booking screens. All right.
And you can keep these because I can always print out more.
All right, so we're gonna formally arraign your case. All right. I'm reminding you that you have an absolute right to remain silent. You do understand your rights, Mr. Bell?
Yes, ma'am.
All right, and defense counsel and you have both waived the formal reading of the accusation, which the court thanks you for at this time. At this time, the case will be set for jury trial, and the jury trial will be scheduled by the state court judge to whom this case is actually assigned. You've been formally charged with failure to maintain lane or improper lane change, driving without a valid license, DUI, failure to maintain insurance, possession of open container, and hit and run, which have all been formally accused by the Solicitor General of Fulton County. At this trial, you'll have a right to an attorney, just as you've had today. You do not have the burden to prove the charges against you. The state represented by the Solicitor General bears that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction against you in this case. If they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000 for each of those charges that I've listed, and they could either run concurrently or consecutively. Based upon all this information I've presented to you today, Mr. Bell, how do you plead to the charges I previously listed?
Not guilty.
I accept your not guilty plea at this time, and at this time, the case will be set for trial. All right, before we get into the bond hearing, Ms. Tyson, can I have the defendant's history, please?
Yes, Your Honor. Mr. Bell, he has 4 pending cases in Fulton County right now. First case is 23 SC 186214, and that's for financial transaction, car theft, safety equipment not used properly, reckless driving, driving while license suspended, and theft by receiving stolen property. Second case is 22 CP 213485, and that's for burglary in the 2nd degree. Third case is 23 CP 219359, and that's for theft by taking. The fourth case is 23 CP 219360, and that's also for a felony theft by taking. He has 41 arrest cycles in Georgia beginning in 2000. He has 7 felony convictions outside of the 10-year period. Within 10 years, he has looks like 2 violations of probation and the 4 pending cases that I listed for you, Your Honor.
Thank you, Ms. Tyson.
Nothing to add.
Thank you. Ms. Nimini, please proceed.
Yes, Your Honor. So I currently have 6 open cases. So bond is currently at the 8,000 signature, based on his missing his trial with Judge Dixon on June 1st of this year. March 14th of 2018, Your Honor, officers received a call from dispatch that 2 parties were sitting in a car parked when a burgundy car drove by the defendant, drove past them in the direction of a schoolyard, turned around and bounced off a trash can and struck Mrs. Richards, the individual whose car was messed up in the front bumper. A black male dressed in burgundy sweater and gray sweatpants jumped out. That's when the parties began to call 911, and defendant complained about them wanting to involve the police, although he just hit their car. He took off running east, jumped over the fence behind the victim's home. Officers arrived a minute later after this interaction. They spoke with the victims, and shortly after, the officer was able to intercept with the defendant, matching the descriptions, and officers approached him and told him that he needed to deal with the wreck that he had just been involved in. Defendant claimed that he knew that he had been in an accident, but was scared of the elderly citizens that were offering to call the police. The officers then ran defendant's information and was able to determine that the car that he was driving was unregistered, uninsured, and defendant's license had been suspended since 2001. So 12 years driving dirty. And then when looking into the car, the officers observed a can of Bud Light sitting in the cup holder between the front seat. And when officers impounded the vehicle, they saw that the 2/3 of the can had been consumed. However, during the officer's interaction with the defendant, his speech was slurred. The scent of his breath smelled of that Bud Ice drink that he was drinking, that they found in the car, and he also had difficulty forming his words, comprehending and remembering to complete sentences during that conversation, which indicate impairment. And during that time, officers conducted 2 sobriety tests. One was the leg stand, in which he was unable to maintain balance by placing both feet on the ground several times, and then walking into a straight line, in which he began to stumble, and after turning around, considering the fact, Your Honor, considering that he has 6 open cases, the case with the possession of firearm, failure to obey signs, false name, possession of marijuana, false statement, the theft by taking that he's currently in Fulton County with, the burglary second degree, and I think there's additional one. Your Honor, the defendant has a tremendous criminal history that not only involves obstruction of justice, not involves battery, not involves drug offenses, Your Honor. And he had a failure to appear with Judge Dixon's for this specific case, Your Honor. The state will want it to stay as said, Your Honor.
Okay, so he originally had an SOB, then he FTA'd and it converted to a surety. That's the posture here. Okay. All right, Mr. McLean. So he didn't actually make bond on these charges. He had a signature bond. Is that correct?
Is that?
So he wouldn't have paid any money if he had a SOB to begin, then an FTA. So it doesn't sound like Mr. McLean, I'll let you speak to that. But if he originally had an SOB, how could he have gone through a bonding company and paid any fees pertaining to this charge?
He believes this one is the Astro Bonding Company. I haven't looked it up, but he believes this one was through a bonding company that sounds like it starts with ASDR. He could be wrong.
I have a wrapping bonding company from 2014, not 2014, from June of this year that was surrendered, but it deals with the theft by taking.
It has nothing to do with this case.
It has nothing to do with this case, Your Honor.
Okay, understood. So his signature bond was revoked. All right, go ahead, Mr. McLean.
Also, our argument has to do with he has a stable mailing address and location of actually residing, not just mail, but actually residing. His mother's house is here in Atlanta. It's within 30314 zip code. And so it's local. He can live there. His brother is local. You know, he's under a lot of stress today, and I understand that we've had some it's taken a few minutes here and there. He's under a lot of stress because he just recently lost his son in a murder case where his son was simply standing on a street corner. Somebody came up and shot him. And the whole family is going through a great deal of grief. And this was just a couple of weeks ago, 3 weeks ago. I've not looked this up 20 days ago.
On the 23rd.
I'm sorry, on the 23rd of September. So I can see what they're going through. I haven't been able to document any of this, given the timing of our hearing. Of course, it's simply an SAP. But I would ask the court to consider he's going through a lot, and he is stable as to residence and mailing. His mother has a phone. He has a phone. And Your Honor, he is employed as he's self-employed as a home improvement person, and is good at what he does and has no trouble getting work. I have been currently over there.
Okay.
Thank you.
Before then, I was at the home from the state house.
What were the special conditions requested, Ms. Nimini? I know you spoke to the amount. Was the state requesting conditions?
Give me 1 second, Your Honor.
Right now, well, I got it just I'm in the home house. I don't know that address. I don't know it's dry.
The state would definitely want him to not drive at all. Considering the facts of this case, considering that he hasn't had a license for 12 years. Yeah.
Okay, so no driving, which we believe is reasonable. All right, defendant is going to receive a $6,000 split bond. For count 1 is going to be SOB through the jail, which is the maintaining insurance. Count 2, SOB through the jail, $1,000. That's the driving without a valid license. The DUI is going to be $1,000 surety. The failure to maintain insurance is $1,000 SOB through the jail. The possession of open container is $1,000 surety, and the hit and run is $1,000 surety. So he has to make bond on the $3,000. The remaining $3,000 is SOB through the jail for a total of the $6,000 split. He is absolutely not to drive without a valid license. Even with a valid license, he's not to drive at this point while this case is pending. And additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything additional, Ms. Nimini or Mr. McLean?
Yes, Your Honor. The state does want to ask for no further contact with Miss Regina, Richard, and Melvin Mitchell, who are the victims in this case.
That's the car that he allegedly struck?
Yes, Your Honor.
Okay, and Mr. McLean, I'm sure you don't object to that, but no contact with the victim. The defense's position?
That's doable, Your Honor. I believe the names of the victims alleged are probably in the accusations themselves.
Okay, so he's to have no contact with those alleged victims.
Very good.
All right.
Even if they're not in there, he can figure that out, Your Honor. Thank you.
Okay, all right. I believe that concludes this case at this time. Best of luck to you, sir.
Thank you.
All right, who do we have next?
I've just got to go see Mr. Valentine upstairs. Other than that, I think, are we through? It's courtroom number 2.
Okay.
Do we have anybody else?
Yes, Your Honor, we still have the females here at ACDC.
All right, I'm ready.
I believe Mr. Howard has each of those.
Position number 6, Miss Estrella Andrea, please come up.
All right, ma'am, your case is 23 CR 005846Y. You're charged with battery, family violence. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, the announcement for this case?
Judge, this is going to be a non-negotiated plea.
Okay. In light of that, can I have the history, Ms. Tyson?
Yes, Your Honor. Defendant, she has 10 arrest cycles out of looks like Massachusetts. She does have a misdemeanor conviction for larceny. Let's see, larceny, assault and battery on family household member, assault and battery on a police officer, resisting arrest, and criminal trespass. That disposition date looks like it's in 2016. It's not giving me the actual day. I just have the arrest date on that one. And then it looks like she has another misdemeanor conviction for larceny over $250, assault and battery on family. Disposition date on that is February of 2018. Her last arrest was June 15th of 2023. Or it says assault and battery. It's not giving me anything specific. No dispositions listed on the GCRC, Your Honor. Nothing to add.
Thank you. All right, Ms. Lemonade, please proceed.
Yes, Your Honor. The state is asking for 12 months to serve 90 days, credit for time served 14 days. Defendant has been in custody since September 29th of this year. Balance probated, no an FIP course, 40 hours of community service, a stay away from 1050 Lenox Park Boulevard, Atlanta, and no further contact with Miss Tatiana, Tatyana Riley.
All right, do you want to give me the factual basis because it's non-negotiated?
Yes, Your Honor. So this incident happened September 28th of this year at 1050 Lenox Park Boulevard. Officers arrived at the location at 11:28 in reference to a dispute with injuries. They made contact with the defendant, who advised that she had been in a dispute with her girlfriend, Miss Tatyana Riley. She advised that she confronted Miss Riley because she felt like Miss Riley had been cheating on her, and she was extremely intoxicated at that point and admitted to assaulting Miss Riley. Her statement is on record with the body-worn camera. She also stated that once officers spoke with Miss Tatyana Riley, she advised officers that the defendants chased her down, hit her repeatedly with her fist in the middle of the street, causing a large knot to her forehead, and the parties reside at the same apartment. Considering her criminal history is limited in Georgia, the state is concerned about her 2016 conviction, assault and battery on a family member, and assault and battery on a law enforcement officer. In addition to the assault and battery on a family member and assault and battery on a law enforcement officer and larceny in 2018 in Massachusetts, that's why the state is requesting the serve 90 days, Your Honor, because it does seem like defendant has a habit of violence, and the state does want to advocate for the victim in this case, Your Honor.
Okay. Is Miss Tatyana Riley on this Zoom conference and wishes to make a statement? I don't see or hear. I don't see anyone with that name, so we'll go to you, Mr. Howard.
Yes, Judge. Mr. Stoll-Andre, this judge is wanting to take responsibility for what happened in this incident. It's certainly not something she is proud of, which is why we're asking the court to consider our recommendation today. I can tell you, Judge, she is a student at Georgia Tech. She's been here in Jordan for the past 2 years because she's studying human resources at Georgia Tech. Part-time, and she also works at Five Church as a sous chef. And she's an assistant manager there as well. She's been on that job for the past 7 months. So she's gainfully employed, she's working, and she's in school, trying to make good decisions, and certainly is not proud of this particular incident. We just don't believe, Judge, that she would be served by spending additional jail time in connection with this. We think it'd be better for her to be released and be able to start the domestic violence counseling, and be able to address, any concerns along those lines that might make it less likely she would be before you again. Judge, our request is that the sentence be 12 months served 26 days, credit for time served 13 days, so that she can be released on probation 28 days, credit for time served 14 days. And she'll be released on probation to do the FB. She's fine with staying away from the 1050 Lenox Park Boulevard address. She's prepared to not go back to that address. We would ask if she needs to go back for anything, that she be allowed a one-time escort, but she doesn't anticipate that she'll likely need to go back to that address at all. Judge, we are asking the court to allow her to enter this as a nolo contendere plea. I don't believe I heard that she's used the nolo contendere plea, so we would ask the court for that consideration as well. But more importantly, we don't want her to continue. It's already impacted her job and potentially her school, and so we don't want to continue to move along those lines by having her incarcerated for an additional extended period of time. So we'd ask for that recommendation.
And the state will oppose to the NOLO, Your Honor,
Okay,
considering the violent nature and her criminal history with assault and battery, Your Honor.
okay. I'm looking up something. She contends she's a current student at Georgia Tech.
She's a part-time judge studying human resources, is what she told me.
Okay. All right. Here's what we'll do. If defendant takes a plea today, has she served 14 days or has she
I'm sure
served-
14.
I'm sorry, Ms. Howard, it's loud where you are. Is it 14 days or is it 13 days?
I'm showing 14. Does the state show 13? I'm showing 14.
I have 14 as well.
All right, so we'll accept the defense's recommendation, where she'll serve 28 days credit for the 14 days. I am not gonna allow her to plead no. She will have to take guilty if she wishes to do this today. And I am gonna make her report to probation the entire time. She would have to report the entire 12 months. It will not go non-reporting, Mr. Howard. Does your client wish to do this and take this plea today?
Yes, yes, Judge, if court indulge me, I forgot to ask for one other thing, but yes, we did discuss the possibility that the court would not accept a no-law, and she still wants to resolve this and take responsibility, so we're willing to do that. Judge, the only other thing I was gonna ask the court to delete the 40 hours of community service. This is a crime, obviously a crime of violence involving a particular person. We believe the DVIP certainly addresses that. 40 hours of community service, quite frankly, Judge, our clients have difficult time with anyone who's trying to find community service organizations. If they have charges of violence, many places will not allow them to even do community service for liability purposes. And we just don't see how it really helps in this type of a case, Judge. It's not a community crime as much as it is a personal. So
if she takes it, I will still require the 40 hours of community service. Does she still want to take the plea?
Yes, Judge. We'll still take the plea.
I do appreciate your position and your advocacy, but I do think I'm giving her a break on the jail time so she can figure out that community service.
Thank you, Judge.
All right. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
You can put your hand down. Are you satisfied with your attorney's representation?
Yes, ma'am.
Do you fully understand this proceeding today?
Yes.
Do you understand that by taking a guilty plea, it may affect other aspects of your life, such as employment, immigration, or any other open cases you may have?
Yes, ma'am.
And you further understand the requirements that you need to complete 40 hours of community service, take a family violence intervention course, have no contact with Ms. Riley, and stay away from the address on Lenox Park? You understand that?
Yes, ma'am.
You further understand that you're giving up your right to trial by judge or jury by taking a guilty plea today?
Yes, ma'am.
And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further, you understand, no one forced you to take a plea, correct?
No, ma'am.
And no one promised you anything in exchange?
No, ma'am.
All right, as to the charge of battery family violence, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from state of defense?
No, Your Honor, thank you.
Thank you, Ms. Nimini. Mr. Howard, if you're muted, if you're saying anything.
Nothing further, Judge.
All right, best of luck to you. That concludes your case. All right, who do we have next? We haven't quite concluded the calendar. Is there an announcement for position 16 reader?
Yeah, there should be Ms. Reed. Yes, we can take that one next, Judge.
Can we take Ms. Reader? Okay. All right, Ms. Reader, your case is 20 CR 003200J. In this case, you're charged with battery family violence. Do you understand your rights?
Yes, ma'am.
All right. What is the announcement, Mr. Howard?
Judge, this is going to be a not guilty plea, and we ask the court to consider, to address.
Okay. And you're gonna enter a formal waiver?
Yes, Judge, I'll submit a written waiver.
All right, thank you, Mr. Howard. All right, Ms. Tyson, can I have that history, please,
Don't hang the phone up. Don't hang it up.
for position 16?
Yes, Your Honor, Ms. Rita, she has eight arrest cycles beginning in 2017. She does have a felony conviction out of DeKalb County, and this is actually juvenile history for theft by receiving stolen property from December 2017. It looks like there's a open case out of DeKalb. Arrest date was December 2021 for, battery, family violence, first offense, criminal trespass, 2 counts of criminal trespass, no disposition listed on the GCIC. Looks like there's another case out of DeKalb County for simple battery. Simple battery, arrest date was February 6th of 2023. No dispositions listed on the GCIC. She has a misdemeanor case out of Gwinnett County that was just accused for DUI, driving while license suspended or revoked, and given false name, address. Let's see, 2 counts of giving false name and 2 counts of DUI. That case was accused September 21st of 2023. And it looks like there's another open case in DeKalb County, arrest dated September 29th of 2023 for criminal trespass and theft by taking, no dispositions listed on the GCIC, and 1 FTA out of Fulton County from October of this year. Nothing to add, Your Honor.
All right, thank you, Ms. Body, please proceed.
Yes, Your Honor. Position 15 and 16 are both hers, 15 being the FTA.
The FTA.
Yes. As to, I believe it's going not guilty. So we would ask in terms of bond, that the bond remains set as it already is. As it relates to this specific case, looks like on May 7th of 2020, officers were dispatched in reference to a fight. Officers spoke with the victim, Anastasia McLean, who stated that her sister, the defendant, assaulted her after disagreement concerning stimulus money, taxes, and helping out with the bills. Officers spoke with a witness, Mrs. Amina Bahir, who stated that the victim and the defendant engaged in a verbal altercation before somebody called out for her to call the police. The officers observed the victim with a swollen right eye, a bloody nose, and a laceration on her forehead. Additionally, the defendant pulled out a significant amount of hair out of the victim's head, which was photographed along with the other injuries. The defendant refused to speak to officers during the interaction. However, when she was being taken to the jail, she did tell officers that she always lets her temper get the best of her when it comes to her sister. Again, and this incident was captured on the body camera. We did speak with the victim, who says she has since moved from that location, and they are family members. And she did corroborate the story in which we just stated on the record. Our main concern as it relates to bond is the open DeKalb County cases. In further view of them, it looks like they are both with battery family violence. And then in the other simple battery case, there was a family member present as well who was considered a victim. So our concern is that there may be something going on here in terms of the family. And so and her violent behavior, additionally with the 2 DUI cases and all of the open cases that she has open right now. So that is our position on bond, that it stayed where it is.
What is that? I don't know the amount.
I believe it's 7,000 on this case coming from the bench warrant.
Okay.
Okay. So look, now I got a chance to pay.
And will you also put the offer onto the record? I know we're rejecting it, but please give us the offer as well.
Yes, Your Honor. The state's offer is 12 months probation to serve 30 days. Credit for time served, I believe it will be 10 days now. The balance probated, family violence intervention, 40 hours of community service, no further violent contact with the victim, Anastasia McLean, and to stay away from the 1757 McKelland Avenue, apartment 8 in East Point, Georgia.
And we're saying that stay away address is no longer valid, correct?
Correct, because the victim
doesn't live there. Okay, Mr. Howard.
Yes, Judge. Ms. Reader is 21 years old. She is a lifelong resident of Georgia. She attended Cedar Grove High School right here in the Metro Atlanta area. And Judge, you know, we did hear the history. This case is related to obviously an alleged altercation with her sister, which was more than 3 years ago. Clearly, her and her sister have had contact since then. I don't believe there have been any issues since this allegation. There's no further violent contact request by the state. I'm presuming because of that. The judge, she actually is, I'm being told, coming from Gwinnett to deal with the DUI, where she spent almost, she tells me, a month on that case in Gwinnett, and then went to DeKalb with the other case that the state referenced, where she was before she was transported here. So obviously, Judge, given her age, we're concerned about, you know, her being in custody for this extended period of time. She does have a 5-year-old son that she's obviously concerned about. And she works at W&B Wing Factory. She was working actually 2 jobs with W&B Wing Factory and McDonald's. She's not sure of the status of the Wing Factory job, but she says that since she's been in custody, she spoke with McDonald's and they indicated they would allow her to come back to work when she's released from custody. And so, Judge, we're asking the court to convert or to set aside the FTA in this case as it relates to the $7,000 bond that's currently set on that. I believe there was an address issue at one point. I showed that she updated her address in March of 2021 to a 1702 Concept 21 address. And I believe, you know, at some point, for whatever reason, she didn't indicate she didn't get that notice where she missed court for a plea and arraignment calendar. But it wasn't an intentional act to abscond or somehow not face the charges. And I didn't hear a history of failure to appear in her criminal history. And since the purpose of bond is not punishment, more so the Ayala factors, and of course, we can address the merits of the charges at a later time. But we'd ask the court to convert this to a signature bond so she can get back to her son, get back to work, and hopefully get back on track in terms of not having these types of arrests. And again, she's a young judge, as the court knows. So we don't believe being here at ACDC or in the custody is good for anyone. So we ask the court to consider that.
Okay, let me think procedurally. I would have to, technically, she has no bond on position 16 and 15, the FTA is what currently has the bond, correct?
That's correct, Judge.
And if you don't dismiss the FTA, do I have the authority to completely dismiss the FTA? Or do I have to change both to some type of bond? Do we know, Ms. Strong?
It's mine, well, Ms. Strong, but I've done set aside orders for the FTA charges before, Judge, to set aside the warrant associated with that failure to appear for fingerprintable charge, and I believe that's worked in the past. Because as we know, when the case is resolved, the state is willing to null process, but in this case, that wouldn't be the case. So, Ms. Strong, would that work? It's worked before, I'm not sure. Actually, I did work with Judge Law recently.
It does. You can set aside the FTA.
Okay, so here's what I'm gonna do. I'm not giving her a straight signature bond. I will set aside the FTA at position 15. And for position 16, she's gonna have to make a $1,500 surety bond. She's to have no further violent contact with the alleged victim. I'm not gonna impose the stay away because of the length of time. Additionally, she's to have no drugs, alcohol, or weapons.
Yes. All right, I'm sorry, and then but 15, what was the bottom line again?
1,500.
Court consider trial, maybe a signature bond to a pretrial on that, so there'll be a monitoring aspect, Judge, to maybe address the court's concerns. But yeah,
I'm just concerned because she didn't show up before, Mr. Howard, and she's got significant history.
And I think the constant contact with pretrial will make it less likely that that would be the case since they're.
Let me see, Ms. Tyson, I know I'd have to send her per judge. My question is, Ms. Tyson, if what's the level where she would have to come every week or make some contact with pretrial every week?
It's misdemeanor, so it's automatically, but we can maybe put a special condition on there where she has to make some type of contact. But usually misdemeanor is once a month.
Once a month? I want her to come more than once a month. I want it to be more than once a month because we've lost her before. All right. I'm going to give her a $7,000 signature bond through pretrial per judge with the same conditions. And I want her to make contact with pretrial at least twice a month.
Okay.
Also bi-weekly contact with pretrial.
Okay.
Thank you, Judge.
All right.
And you said
that's
7, I'm sorry, you said for the amount 7,000?
7,000.
Gotcha. Okay.
Ms. Rita, you're getting a chance. Please don't mess this up. Make sure you make contact with pretrial and do not miss your court date. All right. Best of luck to you.
So much.
All right. Who do we have next? Are we able to take?
Yes, Ms.
Oh,
Holmes, we can revisit Ms. Holmes.
all right. I'm sorry. Did the people appear for the 11 o'clock calendar that we're supposed to have called? Is Reynold Mason on the line?
Your Honor, Attorney Howard, are you finished with Ms. Holmes?
No, we're gonna talk about her really quickly. I just want to see, did anybody show up for, okay, is Telena Perciano on the line?
Yes.
I'm here.
Is Taylena?
All right, I'm making sure, we're gonna get to the 11 o'clock calendar in a moment. I just want to see if you all are here. So that defendant is here. Is Reynold Mason present? We're running a little bit behind.
Mr. Mason, I'm trying to look on the screen to see. if I-
He's not on the screen. Mr. If you have contact information for him, Mr. McLean, will you see if you can reach out? Thank you. All right.
Borrow a phone. Both phones are in use here, so I'll try to borrow a phone.
Okay. I don't know. If you can figure that out, that'd be great. Okay, we're going back to Ms. Hope. Did she want to consider a non-negotiated plea at this time, Mr. Howard?
Yes, Judge, and speaking with her, she does want to now consider a non-negotiated plea in this case. We would ask that the charge be entered as a nolo, and then we'll discuss the other requests as well.
Hold on, let me go back again. I'm sorry, please tell me what position she was again.
7, she was position 7 on the.
Okay, let me, oh, and of course I can't read my notes. I hate to do this to you, Miss Tyson, but can I please have the history again? I cannot read what I wrote at all. All I have is 56 arrest cycles.
My cell phone is.
So I have, let's see, 53 arrest cycles in Georgia.
Okay.
History within 10 years. She has a misdemeanor theft by shoplifting out of Fulton County from 2015. She has a felony conviction out of Fulton County for burglary in the 1st degree, and that's September 2015. She has a misdemeanor conviction out of Cobb County for theft of loss of mislaid property. That's from 2017. Looks like she has another possible open case out of Atlanta. Arrest date was November 4th of 2021 for a misdemeanor theft by shoplifting. No dispositions listed on the GCIC. Let's see. She has 1 FTA out of Fulton County from 2019. And it looks like she has 1 violation of probation from 2021. The GCIC does indicate a hold out of South Fulton. That's also listed on her jailing screen also. And she did have 1 cycle out of Florida that resulted in a misdemeanor conviction for battery domestic violence in 2014. Nothing to add, Your Honor.
Okay. And Ms. Zimini, again, you can put the offer onto the record.
Yes, Your Honor. The state is requesting 12 months to serve 90 days, credit for time served 13 days, balance probated, 12 weeks of anger management, 20 hours of community service, no further contact with Ms. Bernstein Clemens, and a stay away from the 1296 Murphy Avenue Southwest.
Okay, and that would be how many additional days?
Roughly 32, Judge.
Okay. All right, Mr. Howard, your position.
Yes, Judge, as the court heard, one of Ms. Holmes' great concerns is the additional jail time, because she's at the point of where she would lose her apartment if she continues to be continuously incarcerated. She's willing to accept all the other conditions, 12 anger management sessions, community service. She has no problem with no contact with Ms. Clemens. As it relates to the stay away, we asked that it would be limited to Ms. Clemens's apartment number. She lives, it's my understanding, downstairs in a different apartment. But we obviously wouldn't ask that Ms. Holmes be evicted from her apartment, which is upstairs, because of her accepting responsibility in the sense that So Judge, and we are asking that it be entered in the nolo. There is some dispute in the facts, but Ms. Holt believes it's in her best interest to resolve the case this way and substantially agrees, with the state's recitation. So we'd ask the court to make it a 12-month, serve 26 days, credit for time served 13 days, with all the other requirements and conditions as the state.
All right, if she takes the plea today, I would accept your recommendation with the exception that I would require that she plead guilty in light of that history. Does she want to go forward and take this guilty plea at this time, Mr. Howard?
Yes, Judge, we did speak about that, and I believe she's still willing to take the plea, even if it's a guilty plea.
Okay, Ms. Hope, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am, I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am, I'm not.
Do you fully understand this proceeding today?
Yes, ma'am, I do.
Are you satisfied with Mr. Howard's representation?
Yes, ma'am, I am.
And you understand that you're giving up your right to trial by judge or jury?
Yes, ma'am, I do.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am, I am.
And you understand the requirements of this sentence? I'm not requiring additional jail time. However, you're going to have to take 12 weeks of anger management, complete 20 hours of community service, have no contact whatsoever with Ms. Clemens, and stay away from her unit, which we will add to the order. However, you are not required to stay away from your own home. Do you understand all of that?
Yes, ma'am, thank you.
And you understand that taking a guilty plea today may affect other aspects of your life or any other open cases or holds you may have that I may not be able to anticipate, nor may Mr. Howard be able to anticipate.
Yes, ma'am.
And you further understand that I did go through the requirements with you. All right, as to the charge of battery, Ms. Hobbs, how do you plead?
Not guilty. I mean, the guilt, excuse me.
All right, say it again. Let's make it clear.
Guilty.
How do you plead? All right.
Guilty.
I accept your guilty plea at this time. Ms. Nimini, Mr. Howard, anything else, anything further or additional?
Judge, we'd ask that probation either terminate or go non-reporting. Since it's non-DV, we ask that it terminate after completion of the requirements and conditions.
I'm gonna allow it to go non-reported.
Thank you, Judge.
All right, Ms. Nimini, feel free to note your objections that we see on your face. All right, best of luck to you, Ms. Hoax. All right, who do we have next? The only positions I have left is Ms. McLeod's. Are we gonna be able to do that one? ACDC can be excused, I think.
No, I cannot be excused. I have one more that I have to bring up on the competency calendar.
I appreciate it.
I'm gonna bring her up in probably the next 15 minutes.
Do we need to bring her, Mr. Howard?
Yeah, I think in this instance we do. And Ms. Milton, can you get?
Are you sure? I remember.
Yes.
Yeah, based on some things that are going, yes, Judge, that we do, we're gonna need to bring her to this.
So when I bring her, and I said, y'all, we gotta go, we gotta get it done, please.
Well, Ms. Milton, how quickly can you get her? Because the
All right, I'm gonna call them, and as soon as I take these two ladies back down, I'm gonna, with the help of other officers, we'll get it done in the next, it's 11:59, by 10 after, I should be back up.
Okay, and we're gonna need to speak about that position one as part of our competency discussion too, Mr. Howard, Mr. Banks.
Yes.
Okay,
Thank you.
let's do the DV calendar. I don't know, I guess we're gonna continue with the bank. Is Mr. Mason here? Ms. Strong, I'm sorry, will you tell me, did I complete state all purpose? Other than Ms.
Yeah.
McLeod's position 17?
Yes, ma'am. Yes, we have.
Okay, okay, so we are holding on Ms. McLeod's position. Hopefully they will come. In the meantime, we're gonna take up the 11 o'clock DV bench warrant position. I have that position one has failed to appear. Mr. Reynolds Mason, is there an announcement, Mr. McLean, regarding that person's location?
Your Honor, the telephones, there are only two telephones in this room. They're both in use, so I've been able to call him.
Okay.
We did speak to him.
If he gets there by the time we finish competency, I'll consider it, but if not, the bench warrant will continue. All right, we're gonna take up position 20 CR 003201B, the case of Talina Perciano. Ms. Perciano, please turn on your camera and raise your right hand. If we can't see you, you're not here. Ms. Perchiano.
I'm having a hard time trying to open my camera.
You're gonna have to figure it out. I'll give you a few
Okay,
moments.
here we go. Sorry.
All right. All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. All right. Before we begin, Mr. Sirocco, is there an offer on this case?
Yes, Your Honor. The sentence recommendation here is 12 months probation, family violence intervention program, 40 hours community service, as well as a no further contact with Miss Ariana Cole, Arianna Cole, and a stay away from apartment 4001 Lakemont Drive, apartment 151.
Okay, I know that there's Mr. Howard or Mr. McLean. Do you represent Ms. Perchiano?
No, Judge, unless we sent Ms. Perchiano an application and explained she would need to complete that and get it back to us for us to consider representing her today, and I didn't receive it. So she would need to proceed on her own at this point.
Okay, Ms. Perchiano, you were entitled to have representation, but you did not seek the services of the public defender's office. Therefore, there's no one here to assist you. However, you do have a right to an attorney. There is currently a bench warrant out for you at this time. So what I'm going to do is you can either consider this offer as presented by the state. Unfortunately, I can't give you any legal advice. If you want to speak specifically to Mr. Sirocco, I will permit you to do that in a breakout. However, do not give him any defenses because whatever you tell him might end up being used against you. Or we can proceed and just discuss the bench warrant issues today. Understanding you have to have a significant reason to explain to me why you did not appear. And if so, if I find that the reason that we have is not significant, then you would have to surrender yourself within 72 hours to the Fulton County Jail. So would you like to speak to Mrs. Sirocco briefly about the offer that he just put onto the record?
Yes, ma'am.
Okay. Can we put them in a breakout? But again, do not give him your defenses. Just listen to the conditions. He can explain to you very briefly about what the FBIP might involve, okay?
Okay.
All right. So Ms. Strong or Ms. Grace, will you put them in a breakout, please? And if the supervisor needs to go as well, I'm not sure if Ms. Falk needs to join.
I do, Your Honor.
All right, please add Ms. Falk. All right, we're going to be on a very brief recess. Mr. Howard, if you want to start maybe making a way to a place where we can discuss competency, unless you plan to do it there, which I don't think you can. Okay, very brief recess. All right, your announcement, Mrs. Sirocco.
Yes, Your Honor, we've informed Miss Perciano of the state's offer in this case. We're not sure as to her position on that at this moment. She did inquire about having the public defenders represent her. I'm not sure if that's possible today, given that court is today.
It's not. So either we go forward with the bench warrant calendar, or you consider and take that plea yourself, Ms. Perciano. Which would you wish to do?
I'm going to take the plea.
Are you sure?
Yes, Your Honor. Additionally, we want to ask that the bond be revoked and the defendant remanded to Fulton County Jail with the bond changed to a cash or surety. Oh, excuse me.
Even if she takes the plea, that's what you're asking for?
Oh, no. I apologize.
Okay. I was confused for a moment. She said she wants to take the plea offer.
You're right.
She would not have to. Okay, are we able to send her plea paperwork? She would need to do that before she. Miss Perciano, do you have a way to sign plea paperwork on your phone? Because you're not in the Fulton County Jail, you would have to sign paperwork before I release you today. Do you have a way to do that?
Yes, if it can open up on the Microsoft, when I Word PDF, I'm able to either type or write.
Okay. So Mrs. Sirocco and Ms. Falk, if you would start preparing paperwork for her, I'm going to ask her some questions to make sure this is a voluntary plea.
Yes, Your Honor. I'll prepare the paperwork and send that over.
Okay, and Ms. Perciano, will you please put will you chat Ms. Falk really quickly an email address where you can receive the documents?
Yes, ma'am.
And normally, yes, the public defenders would have assisted you today, but they had to pre-qualify you because you're not at the Fulton County Jail. Had you been at the Fulton County Jail, you would have been entitled to their services today. All right. All right. So I'm going to ask them some questions to make sure this plea is voluntary. Okay. And
yes,
I placed you under oath already. So you're reminding you that you're still under oath. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your knowledge of an explanation you received from the state today?
Yes, ma'am.
And you understand that you did have a right to an attorney. However, the public defenders were unable to assist you today at this time, and you chose to go forward and take a plea. Is that correct?
Yes, ma'am.
And you further understand that by taking the plea today, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements. We are not seeking any additional jail time. However, you would have to take a family violence intervention course, complete 40 hours of community service, and have no contact with Ms. Cole and stay away from that location. Do you understand all of those requirements?
Yes, ma'am.
I'm sorry, Mrs. Sirocco, will you put onto the record the relationship between those two?
Yes, Your Honor. The two were dating back in 2020. It's clear that they had a relationship then. Yes.
Understood. And you're no longer in a relationship with that individual?
No, ma'am.
All right. And do you reside at that location on Lakemont?
No, ma'am.
All right. So that stay away, you understand that you can't go back there, correct?
Yes, ma'am. I also have a question. I sent my email into the chat, but it's saying unreadable. Am I supposed to personally send it to someone?
Okay. Is Miss Body where you chatted us?
It's in the chat.
Yeah, I can see it. It's the AOL.com.
What happened? Miss Body chatted something that says an email came back as undeliverable. So that might be what we're all looking at.
Yes, that was in reference to Miss Thomas.
Okay.
Yes,
I think something's happening when we're seeing private chats today. That's been happening all morning. Okay, I would personally prefer to disable the chat. All right, Ms. Perciano, you understand that by taking a guilty plea today, other aspects of your life may be affected that I can't anticipate, such as employment or immigration, or if you have other open cases, you understand all of that?
Yes, ma'am.
As to the charge of simple battery, family violence, how do you plead?
Guilty.
Hold on one second. Ms. Tyson, I'm not, yes, Ms. Tyson, are you still here?
I am here.
Can I have the defendant's history, please?
Okay, just give me one moment, Your Honor.
Yeah.
I didn't even have a count. Give me one. moment.
Yeah, I'm sorry. Her name is Selena Perciano. What I'm interested in is whether she has pled NOLO in the past 5 years. Mr. Sirocco, any objection to her pleading NOLO if the history supports a NOLO plea?
Yes, Your Honor, this is a domestic violence incident, so we are objecting to NOLO at this time.
All right, so I'll leave it to the court. Let me hear Miss Tyson's, the history from Miss Tyson.
She has 3 arrest cycles beginning in 2015. I do not see any felony convictions, no misdemeanor convictions either. Yep, nothing to add. That's it.
Okay, so I'm gonna allow you to plead NOLO despite the state's objections. All right, Miss Selena, I also need to ask you this. Did you agree that this case took place in Fulton County?
Yes.
And do you agree that they have the proper defendant being you?
Yes.
And Mrs. Sirocco, I need you to briefly put the facts so that she can stipulate to those.
Gladly, Your Honor. So law enforcement in this case was dispatched to 4001 Lakemont Drive, apartment 151, in response to a domestic call. Once there, officers met with the caller and the victim in this case, Miss Ariana Cole, who stated that her girlfriend, the defendant, was hitting her. The two had been arguing all day, and the defendant got upset and hit her in the face. Ms. Cole stated further that she left home with the defendant's sister because she didn't want to be hit anymore. Ms. Cole said that when they returned and asked the defendant to come help with groceries, the defendant began yelling, throwing things at her, and hitting her. Law enforcement spoke with the defendant, who stated that the two were arguing throughout the day and that she, the defendant, got upset and started hitting her out of frustration. Both the defendant and Ms. Cole stated that the defendant was the primary aggressor and started hitting first. The defendant's sister, Chanel Perciano, confirmed that the defendant struck Ms. Cole several times once they returned from the store. Officers then placed the defendant under arrest.
All right, do you stipulate or agree with those facts, Ms. Perciano? If you don't, we unfortunately cannot take your plea today.
I do.
All right. As to the charge of simple battery family violence, how do you plead, Ms. Perciano?
Guilty.
No, I told you you can plead NOLO. I'm gonna accept you're gonna tell me you plead NOLO.
Okay, well, NOLO.
All right, I accept your NOLO plea at this time. After defendant has completed the FVIP program, her probation can go non-reporting. All right, anything further, Mrs. Sirocco?
Nothing from the state, Your Honor.
All right, Ms. Perciano, I need you to stay on the Zoom conference until we confirm that you have that paperwork for Ms. Falk. We're gonna have you sign it and send it back, okay?
Okay.
All right. All right, are we ready to take is Mr. Howard back on the Zoom?
Your Honor?
Yes.
And Mr. Howard? The young lady said no, she refused.
Okay, understood.
Okay, all right.
So Ms. Perciano is gonna stay on the line temporarily while we get her the paperwork, and we're gonna go into the breakout to discuss the competency. But before we do that, can we review state all purpose, Ms. Strong, so that those who are only here for state all purpose can go ahead and go to lunch? And Mr. McLean, if you would please try to get a hold of the gentleman from the DB calendar. I'm hoping that there's now a phone available to you. And we also are still holding on Ms. McLeod's position. At courtroom 2, is that party gonna be brought? I'm sorry, Mr. McLean, it's muted. We can't hear anything you're saying. Mr. Riley, is he gonna be brought?
I don't, oh, I'm sorry. I don't know about Mr. Riley. He is the conflict person. Do you know if Mr. Riley is going to be brought into the court?
Is Mr. Riley gonna be brought?
Hold on.
Okay, unfortunately, Ms. McLeod, we're gonna have to hold. I don't know what's gonna happen, but we're gonna go ahead and review state all purpose with the exception of that position.
Yes, Your Honor.
All right.
We have no info yet on Mr. Riley's transport into the courtroom or not.
Okay, so I'm gonna assume we're holding until I hear something else. And unfortunately, I cannot release everybody then because we might still need pretrial and probation. Let's hold a few more minutes and we'll go ahead and go into the breakout room, please. So it'll be me, is Ms. Burgess, Ms. Falk, Mr. Howard. Is there anyone else that needs to come?
Ms. Strong?
Ms. Strong, of course. I thought you put yourself in there.
Oh, no, Miss Grace is doing it. She's the
Put you
host.
in there. Okay.
Okay, so Ms. Falk, Mr. Howard, Judge Williams, and who else did you say?
Ms.
Caution.
Burgess.
Yeah, okay, just one moment, Judge.
And Ms. Persiano, I just sent the paperwork to you. You should receive it shortly.
Okay, I'm gonna check and refresh a couple of times. Okay, I have the paperwork. I'm going to open it up.
It says defendant, you just need to sign everywhere where it asks for your signature on the first, second, and third page, and then send it back to me.
Okay, everywhere where it says only defendant.
Correct.
Okay. Okay. Mm. Okay. Ma'am. I don't think she's on.
How can we help you?
Hold on. I know she said just fill out the line where it says defendant. Should I also fill out the line where with my name where it says we, the jury, found the defendant? Should I put my name there too or no?
You can place your name there.
Okay, thank you. Okay, I'll be sending it back shortly. Okay, I believe I sent it over. Make sure. No, it's coming up blank. Okay, one moment. I have to resend. Because okay. Okay, I believe the paperwork was sent through. If someone could tell me if they got it.
Yes, Ms. Falk is in a breakout room right now. As soon as they come back out, she'll let you know whether or not she received the paperwork.
Okay, thank you so much.
Mm-hmm.
Ms. Perchiano, Ms. Falk is gonna give you some instructions about the paperwork you just sent back to us. All right?
Ms. Perchiano, are you here? Oh, no.
I don't see her.
She left.
Yes, ma'am. I'm here.
Oh, okay. Oh, thank goodness. Ms. Perchiano, we cannot accept just you typing your signature in. Do you have any way to print out the paperwork and scan it back to us?
No, but I believe I could, it's a way you can actually write on there too.
Okay, so can you do that and sign your signature on there?
Okay, on each of the lines, or is there a specific line?
Nope, on each of the lines.
Okay,
And then send that back to me. We'll see where we are.
okay,
Okay,
thank you.
thank you.
And does courtroom 2 have an announcement regarding the one position we are still holding on that belongs to Ms. McLeod, Mr. Riley? Or does anyone have an announcement?
We do not have an announcement on that, Your Honor. I noted that it was A11 location. A11 is a cell location in South Annex, which is what they call Union City nowadays, not the ACDC.
Oh, is Union City on the line? No. Can someone at least call Union City before we go? As he's never even spoken to Ms. McLeod? I don't want to reset without that if possible.
Okay, Judge, let me see. Can I reach someone?
Thank you, Miss Grace. I appreciate that. And even if he can just, Ms. McLeod can at least relay the offer that we have on that case, at least that, and have the opportunity to interview her client. Ms. Strong, will you review the calendar for us? That actually is a good use of our time.
Give me a second. You ready, Judge?
Yes, ma'am.
Okay, position number 1 was null pros. Position number 2 was a not guilty reset jail jury with an amended bond. $6,000 split bond, $3,000 signature bond through the jail, $3,000 surety bond. Position number 3 was a negotiated plea. Position number 4 was null pros. Position number 5 and 6 were negotiated pleas. Position number 7, negotiated plea. Position number 8 was release, reset further notice. Position number 9 was a not guilty plea, amended bond of $7,500 signature bond through the jail. Position number 10 was a negotiated plea. Position number 11, negotiated plea. Position number 12 and 13 were null pros. Position number 14, negotiated plea. Position number 15, the FTA warrant was set aside. Position number 16 was an amended bond, a $7,000 signature bond through a pretrial. Position number 17, we're holding on. Position number 18 was null pros. Position number 19 was a negotiated plea. Position number 20 was transferred to Superior Court, and position number 21 was a negotiated plea. On the add-on calendar, 1 through 4 for negotiated pleas. On the DV bench warrant calendar, position number 1, the defendant did not appear, so the bench warrant stands. And position number 2 will be a negotiated plea once the paperwork is sent in.
For position 1, you said it was no pros?
Ms. Faulkner, all pros, position number 1.
Yes, Ms. Nimini, I can let you know about what happened in the competency calendar offline.
Mr. McLean, are you still there? Is Mr. McLean gone? Was anybody able to reach Mr. Mason?
Judge, this is Ms. Grace. We were unable to get anyone at the South Annex. They have a new number from Mr. Jordan, and I tried calling out to courtroom 2, but no one answered to see if they had a number for them.
Okay. Is anybody at courtroom 2 with you, Mr. Howard?
No one else is here, Judge. Mr. Mason did not respond. Ms. McLean is here with me, but he, the gentleman you asked about, we weren't able to get, hadn't responded.
Okay, and we don't have another, there's no other number to call. No one knows the number to call South Annex?
36637.
36637 is the number in ours.
Ms. Grace, will you try to reach them on that number?
3637.
36637.
Yes.
We have a live person on the phone from Union City. This is my McLean public defender.
And I wanted to reinstate, I know we haven't done Ms. Perchiano, but hers will be a nolo plea. I'm sorry, I said negotiated.
Which position would that, Ms. Strong?
Position 2 on the DV bench warrant. We're still holding on her paperwork. She believes she can submit it to us.
JARVIS.
So
last name is 2 words.
Ms. Falk, whenever you receive Ms. Perchiano's paperwork, please let us know if it's sufficient.
A11.
And we'll hold a little bit longer on Ms. McLeod.
Your Honor, I was able to find someone from the Orca team who was not removed from 141. They are going to send that paperwork through DocuSign. And so
that's actually better. So
yes,
we're gonna hold and make sure Ms. Perchiano gets it and sends it back so that if we have to hold the calendar for that purpose.
So, Ms. Perchiano, you should be receiving a document via DocuSign from Ms. Sarita Githia.
Okay, I also sent back the document. If the typing, I mean, if the signature is too big, I could do it all over again, but
No,
it is signed.
just do the DocuSign. That one is better, and we can confirm that it's an actual signature, okay?
Correct.
So just
Okay.
when you get that, open that up, and we're gonna wait for that. Please do that as quickly as you can, okay?
Okay.
And you should get it shortly.
All right,
Judge, that number I tried for Union City went to voicemail. Nothing.
Ms.
Judge,
McLeod.
We were able to speak. We're on the line with them.
Oh, okay, thank you.
So we
They're gonna
guess
zoom on as soon as I get them.
Deputy Norris gonna work out getting a Zoom link to Union City.
Okay, perfect. So Ms.
We'll
McLeod
get
will
it.
be able to speak to them.
It's on the upper right hand, upper left hand.
You wrote it down.
Good morning. I have a question. This is Ms. Thomas. Are we done with SAP?
Unfortunately not. We have one more position. And if we
Okay.
can't get them in the next few minutes, hopefully they're coming on the line now.
No problem. I just don't want to leave without knowing.
Yeah, we're not quite, Ms. Thomas.
Okay, thank you.
Okay, thank you.
May the person who sent it over my paperwork let me know when they do send it, because I did not receive anything just yet.
Your Honor, we are sending it via DocuSign. The attorney just let me know they do not have the defendant's waiver right on DocuSign of their right to counsel. So I just wanted to advise you of that.
Okay, that they don't?
I'm
What
still
is that?
muted. Okay. Okay, send the Ms. Falk, if you would send those, the ones that you have. Let her send DocuSign the ones that Ms. Giffier does have. And do you have that waiver of rights to counsel form?
I do, and she sent it back to me, and oh, she was able to sign it.
Yeah.
It's a little wonky, but it's a signature.
Okay.
I'll forward it to Your Honor and Miss Strong, and you guys can make the determination if it's sufficient.
If we don't need DocuSign, we won't use it. Let's take a look. Thank you, Ms. Falk. Hold on, Miss Perchiano, just hold on 1 minute.
Yes,
and
ma'am.
let us look at what you sent. Okay, we're gonna accept it only for the waiver of right to counsel, but we still, Ms. Perchion, please try to fill out the DocuSign. Did Ms. Givier send it yet, Ms. Falk?
Your Honor, let me follow up with her right now, but I
Okay.
did request that she just go ahead and send the paperwork without the
Without
last
it.
page.
Right, we'll accept this last page, but I prefer the others to look a little different if possible.
Okay.
So please look out for that DocuSign. We may have to, is South Annex gonna be able to come on the line? Does anyone know? Mr. Howard?
I'm gonna have to put you on hold, Mr. Mason. Hold on.
Judge, we're on the line with them, trying to figure out, we gave them the meeting ID in the past, so
All right.
are they
And
logging?
they don't know how to get in?
Give me that number, 3367.
So we're still trying to figure out why they haven't logged on, Judge. We did speak with someone there. And
Okay, is that defendant there?
Yeah, just
we assume so, Judge. She just said he would, he would get on.
Understood. Thank you, Mr. Howard. You get the Snicker bar of the day, you and Mr. McLean.
All right. Hey, are y'all logging on? No.
And Your Honor, I just, Ms. Githier said she's about to send it momentarily. She had to reformat it without that last page.
Okay, thank you.
I have a question, Your Honor.
Yes, ma'am.
Am I filling out the whole entire paperwork or I'm just placing a signature at the bottom?
She should just be placing a signature. Oh, I'll let Ms. Falk answer that because I'm not looking at it.
I can't hear her.
You're muted, Ms. Falk.
I just realized that. That is correct. Can you send me what was sent to you just so I can look at it as well, so we can be on the same page?
Yes, ma'am.
Okay, great.
Oh, I have a question of Ms. Graves or Ms. Strong. I was writing down on the 6 counts on case number 2, 3,000 was a total of 1,000 each on 3 counts. Sign on bond through jail. Or was that pretrial?
It was 6, 3,000 to the jail, 3,000 surety. 6.
Right. Now, the 3 that were actually surety are the DUI count, the hit and run count. And what was that third thing? Was it the possession or was it
The possession of the open alcohol container.
That's what I thought. So counts number 3 and 5, 6 were the sureties. Everything else is the SOB through the jail. Thank you. I'll write that up. Your Honor. No, you just want to-
Yes.
I had left a message when, as soon as the phones got free, because they had to use them for SEA, I called Mr. Mason again, and he dialed back and said that because he is residentially challenged, he went to a McDonald's to sign on and could not get the Zoom to work. He could not sign on their public Wi-Fi. Your Honor, would he have permission to come next week and just come in person to G33? I don't think he's going to be able to make Zoom work.
Mrs. Sirocco, you're still here?
Yes, Your Honor.
Okay. Tell me, I know the state is seeking to keep his bench warrant in place. Did he ever have any returns to sender?
Can you repeat that, Your Honor, as well as the
Position 1, did he have any returns to sender on the DV reset calendar?
I don't have this particular position in front of me, Your
That's
Honor.
not yours. Is it
No.
yours? Whose position is position 1 on the DV reset calendar?
I can address it, Your Honor. That one, there was a failure to appear. I'm not seeing any returns to sender on that 23. This is Ronald Mason, correct?
Right.
Yeah, I'm not seeing any returns to sender when I go into case intake. He was released on January 17, 2023. He failed to appear on September 19th, 2023. The rule NISI was issued September 26th, but there was no return to sender mail that was uploaded into case intake.
Okay. So apparently he got the mail, Mr. McLean.
When fully intended to Zoom on, but he has no Wi-Fi because he is not at a location. He is homeless. So he went to a McDonald's restaurant to use public Wi-Fi and couldn't make it work. I don't think I've ever tried to make a McDonald's Wi-Fi work, so I have no idea what the problem was.
I just feel like is it possible to do a DV? Miss Strong, I think it's doing something else. Miss Grace, is it possible to do a 1-week DV reset calendar? Can we have one for next Thursday? If we can't, then I'm gonna have to think of something. I'm gonna look at this differently.
Yes, that's fine.
Okay, we're gonna reset Mr. Mason 1 week. He better figure out how to arrive. I don't know if he can even go to, I don't think he can go to G33 because typically the reason I'm not there now is because there's jury trial and other calendars happening there.
Oh,
So there really is no physical place for him to be.
Maybe come here.
He can come to 901 Rice Street, courtroom number 2.
Well, I'll let you tell him how to appear. All right.
Thank
But
you.
he has a 1 week reset, but the bench warrant is still active. So if he gets in trouble between now and then, he's gonna end up at 901 Rice Street anyway.
Understood, Your Honor.
Okay. And what about our status of our paperwork? And status of South Annex. Ms. McLeod, if they don't come on soon, I think we have to have no choice but to put him on for next week.
Yes, Your Honor. And I do believe the state's offer in that case was not going to allow him to get out today anyway. So I don't feel really bad, like, he's going to be staying. I think offer was one which would require him.
I wanted you to at least be able to speak to him. Now
I would like to speak to him as well, Your Honor.
But I don't think it's going to happen. We've been trying for about 30 minutes. And I think that might be all of our threshold of tolerance, but we'll see. Ms. Falk, did you get any, Ms. Perciano, did you get any paperwork to send back? Are you, is it complete?
I have Your Honor, it does not appear to be complete. It looks like so she has to check the boxes on DocuSign just to notate she understands the rights that she's giving up. And what you explained to her verbally on the Zoom. So it looks like none of those were done, and I'm not seeing a signature either.
I didn't complete the form because I was trying to figure out if I had to actually check the boxes or just sign my name. But now that I know that I have to check the boxes, I will go and check the boxes and sign my name. I also just received another waiver that I have to sign and send back.
You do not need to sign the other waiver. Just do the form for DocuSign, fill out, check the boxes, sign, send it back.
All right, Ms. Perciano has sent us something. I believe she's going to do this DocuSign, correct, Ms. Perciano?
Yes.
Okay, if you don't do this DocuSign, what's going to happen is that bench warrant will still be active. So go ahead and do this. I'm going to go ahead and allow you to go because we did get something with your signature. Okay, but please still fill out the DocuSign in its entirety as Ms. Falk just explained and send back to her. Okay.
Okay, will do.
All right. Let's last sound for South Annex. Is the South Annex coming, Mr. Howard or Mr. McLean? Do we know? I know they were trying. Did they figure it out?
We're on hold with South Annex.
We called them back, Judge, but we don't see them on the Zoom yet for whatever reason. Deputy Norris emailed the Zoom link even after we gave it to him on the meeting ID and passcode.
Okay, well, I don't know. Is Miss Grace, is there room on Tuesday's calendar for position 17 as an add-on? I hate to do that, but we might be at that point. I'm willing to wait, but it doesn't sound like they're gonna get this.
And Your Honor, not to kind of pile on to what the conflict PD said, but we will say he has a number of cases that are he's currently incarcerated in, including armed robbery, aggravated assault, hijacking a motor vehicle, et cetera, et cetera, et cetera. So even if we resolve this case today, he is sitting.
Right. He's not prejudiced by us resetting him to next week.
That is correct.
All right, Miss Grace, what's the earliest I can reset position 17? Or I know I sent Miss Strong do something else. I don't know if she's back.
Yeah, he already sent it out for Tuesday. Today we can do an add-on for next Thursday's judge.
Okay, so Ms. McLeod, we're resetting your client to next Thursday as an add-on. I hope that you can speak to him prior to then. Now that you know that he is at Union City, please try to make contact before then if you
Yes,
can.
Your Honor, I can actually go see him up there.
Okay, wonderful. And he'll be on next Thursday's calendar. All right, everyone, thank you so much for your patience. Ms. Grace, please let Ms. Strong know that as well, that we reset position 17 for next Thursday. Are there any other questions or comments about the calendar? Okay, hearing none. Any other comments? And we believe that Ms. Perciano is going to send that paperwork. Once received, Ms. Falk, please send it to us.
Will do, Your Honor.
All right, everyone, take care. Have a great and safe weekend. Bye-bye.
Thank you, Your Honor. Same to you.
Thank you.
Your Honor. Your Honor.